good job for the citizens.
It is now 8:45. The meeting of the Texas Commission of Licensing and Regulation will come to order. Commissioners, you can see we have a full house. We must be a YouTube sensation because, as you know, our meetings are streamed on YouTube. So I guess everyone's here for that. So I appreciate y'all being here to watch us in action. So let's move on to item B, roll call.
Mike Hernandez.
Present.
Tom Butler.
Here.
Colin Collier is absent today. Rick Figueroa.
Here.
Robbie Shaw is absent today. Deborah Yurko. Here.
We do have a quorum present for this meeting. I'm going to, Commissioners, just so you know, I am going to be skipping around quite a bit today. We do have we're barely making a quorum, so there's a lot of items that we need to take up that we have to have done by today. And just for your information, I will be around the noonish hour. Unless the meeting gets really bad, I'll leave before. And then which means that we'll fall below quorum at that point in time. So there's a lot of items that I'm going to be skipping around on. So if you trust me to keep up with everything, or trust Kay, we'll just plan on handling it that way. So at this point in time, let's go on to item E, approval of the minutes. You've had a chance to review those minutes. A motion would be in order.
I move to approve.
We have a motion, second, to approve the minutes. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's move on to item H, review and discuss possible action to approve the fiscal year 2017 annual internal audit report. We have Garza and Gonzalez before us. We had a subcommittee meeting prior to our meeting here. Vice Chairman Butler and I were in attendance. I don't know if there's anything you would like to say about it. If not, if you don't mind, state your name for the record.
Sure. Mr. Chair, members of the Commission, I'm Kim Lopez-Gonzalez, and I'm representing Garza Gonzalez and Associates, the internal audit CPA firm that has performed the internal audit function for TDLR. What we are here today to present is the annual internal audit report for fiscal year 2017. In addition to that, we do have the other 4 reports that we also are issuing at the same time for the programs that were audited as part of the fiscal year 2017 approved internal audit plan. The annual internal audit report does follow the format as provided by the State Auditor's Office, and it does not change from previous years. As I indicated before, the 4 reports that, in addition to the annual report, is the Combative Sports Program Audit, the Performance Measures Reporting Audit, and also the other programs audit. In addition to that, we did perform a follow-up of the prior year internal audit reports. With the Combative Sports Program report, there were 4 comments and recommendations. In addition to the recommendations that are included in that report, management's responses are also included. Management does have a chance to review them. We do work very closely with management in ensuring that we do have our facts straight and provide them the opportunity to provide their feedback. And after that, they do provide their responses. All of the responses have been positive, and they are in agreement with those comments and recommendations. For the performance measures reporting, we did have 2 comments and recommendations included in that report. The same for the Combative Sports Program. They are in agreement with those comments and recommendations, and their management's response is included. We performed a follow-up on the prior year internal audit recommendations that were not fully implemented as of the prior year, fiscal year 2016. There were a total of 30 comments and recommendations that we followed up on as part of that follow-up that was performed. we will perform a follow-up next year on any of the items that were not fully implemented as of that date. Of the 30 total, there are 10 and a half that were fully implemented, so all of the other one, and 2 of them that were not implemented, so 17 and a half of those recommendations will be followed up next year as well. So the annual report does summarize that. In addition to that, there is other programs, which was the weather modification program and the polygraph examiners that were included in that audit. As a result of that audit, there were 2 comments and recommendations from that, and management's responses included in there where they were in agreement with that. So this annual internal audit report is required to be approved by the TDLR and submitted to the State Auditor's Office, LBB, and other state agencies by November 1st. In addition to the reports that we are providing on page 7 of the annual internal audit report, we do have a proposed internal audit plan for fiscal year 2018. Now, keep in mind that that is just based on the 2017 risk assessment. When the 2018 risk assessment is performed, of course, that most likely will change based on the new programs that have come under your umbrella. So I'll open it up to any questions, because I know that there was a lot of information included in all the reports, just in case there are some questions that you may like to have answered from those individual reports.
Any questions?
And I'd also like to indicate that based on our audit, like I indicated, we do work closely with staff. We set the scope of the audit. We asked for a lot of information, and we were not. The information was provided timely, and we do ask information. After we ask for some information, we ask for more information, and we were not restricted in any form or fashion. So I did want to indicate that.
I do want to commend Carla and her group. I know that we've definitely stepped up. I hope we've stepped up our game with Carla now on the driver's seat there. So
thanks, Mr. Chairman. I take that to heart. That the new deputy's doing a much better job than the old deputy did. Thank you very much.
We can only go up.
We can only go up.
So, any questions at all? A motion would be in order to accept the audit.
Make a motion that we accept the audit for fiscal year 2017.
A motion, second. All in favor signify by saying aye.
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 Those opposed, motion carries.
Thank you.
Thank you very much. I appreciate it. Thank you, Mr. Commissioners, I failed to request a excused absence for Commissioner Helen Collier and Commissioner Ravi Shaw for a meeting for today when we were taking roll call. So at this time, I would entertain a motion to excuse their absence.
Second.
Motion is second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Ms. Mayhaw, did we receive the comment form from Nels R Us? I believe that they were supposed to, are they present? Which is motion for rehearing? There's someone here for Nels R Us, motion for rehearing? Okay, all right. I would make note also, I've noticed some people have entered into the meeting room. If you have a case that you're here for, a motion for rehearing, and you have not filled out a form, I would ask that you fill out a form and get it to Ms. Mahon over here so we can get to your cases. As I mentioned earlier, we are pressed for time. So the plan, Commissioners, is to take up the cases and motions for hearing of individuals that are here so that we can go ahead and address those cases that have come before us. So, yeah, just go ahead and take it there. And then that way we can get those covered. And if we have time at the end, we'll come back to the case and motions for rehearing to consider. But if not, we'll push them to the next meeting. At this point in time, what I would like to do is to move on to the item N, approval of appointments of advisory board members. Commissioners, you have before you a list of members that I am recommending for either appointment or reappointment. This particular item we do need to get done also because of the fact that we have new programs that begin with us November 1, and we have to have these boards in place so they can start meeting after the November 1 timeframe. So you have that before you. I do have someone here that wishes to speak. Patrick Barrett. N. Item N.
Is this working?
should, yes.
Thank you so much.
All right.
Mr. Mayor, if you don't mind, state your name for the record.
Yes, sir. My
You
name,
have 3 minutes in which to speak.
I'll be done in less than that. Thank you. My name is Patrick Barrett. I'm the owner and author of Parent-Taught Driver Education course, Driver Ed in a Box, and also I own a driving school, Collision-Free Driver Ed. And first of all, I want to thank all the members for serving on the commission. I appreciate that. And also, I would like to compliment the TDLR for its efforts in regulating our industry and the current advisory board for driver education and safety for its work in updating the rules and regulations. Today, I have 2 concerns that I'm addressing. One, the replacement of the advisory board members whose terms expire, and secondly, a desire to see an improved communication from the TDLR to our industry. I'm asking that you replace the members of the Advisory Board for Driver Education and Safety whose terms expire this month with individuals from the industry who are not currently on the board. It's important to bring in other people from industry to replace those whose term expires. One reason by rule is that no member is permitted to serve consecutive 6-year terms. We don't want the same people on the board all the time. I attempted to ascertain these facts from the TDLR. I wasn't able to get an answer. I contacted Mr. Butler, who I appreciate taking the time to visit with me. He had Mr. Francis call me, who certainly addressed my concerns. My main concern is to make sure that we don't allow the advisory board members to serve consecutive terms. If any of the 3 individuals is reappointed for the coming term, that person or persons will have served 8 consecutive years. I think that's contrary to the intent of limiting an individual's terms to 6 consecutive years. Secondly, to improve the communication our industry receives from the TDLR. Actually, I commend the TDLR for its efforts in soliciting comments from the industry, conducting summits open to those in the industry who seek to provide suggestions and identify best practices that serve the public interest. And overall, having been in the driver training and education business since 1974, and having been regulated by several and various agencies, I give the TDLR and its executive director, Brian Francis, high marks for the manner in which it regulates us. Initially, when applicants for the advisory board were sought, we in the industry received communications from the TDLR. However, as terms are expiring and members need to be replaced, it seems that there was little, if any, communication sent to the industry soliciting new applicants for the board or reminding those who had previously applied that they need to update their application. Perhaps we can learn from that, and maybe the TDLR can improve its communications regarding something as critical as seeking new members for the advisory board. Thank you very much for your attention. I respectfully submit to that and appreciate all the work that you do.
Thank you, Mr. Barrett.
Thank you, sir. Any further comments at this point in time? Commissioners, you do have before you a list of appointments for various committees. Let me go ahead and read those off. These would be new programs that we have coming before us beginning November 1. The Behavioral Analyst Advisory Board, I recommend to you to appoint William Borland as a presiding officer, Ellen Cote, Sarika Cuellar, Wesley Dotson, Dr. Joyce Mock, Brian Russell, Carol Sloan, Lori Snyder, and Stephanie Sokolowski to the advisory board for the behavior analyst. On Code Enforcement Advisory Board, I recommend appointing Teresa Adrian as a presiding officer, Richard Adams, Jennifer Bernal, Matthew Christensen, Christella Miles, Stuart Walker. Massage Therapy Advisory Board, I recommend appointing David Lauerstein as the presiding officer, Carolyn Guerin, is that correct?
That's correct.
Raymond Rust, Susan Sparks, Paul Stone, Karen Vasquez, Carol Willis. On the Registered Sanitary Advisory Committee, I recommend appointing Jim Dingman as the presiding officer, Dalton Knight, Stephen Katsatos, Sean May, Lisa Pomeroy, and Terry Ricks. Those are new programs that are coming over to us. I would also make note that the Towing and Storage Advisory Board, there were some changes made in the legislative session that removed some positions that were there prior to. So we've gone through there and had to reappoint some of those, or appoint some individuals. I recommend appointing Jeremy Clark, Thomas Griffin, Kyle Jackson, Tasha Mora, and Jimmy Zolke. I also recommend reappointments to the Architectural Barriers Advisory Board of Ronald Menard, Kathy Ann Riley, and Brian Sargent. Dietitians Advisory Board, I recommend Irma Gutierrez and Matilda Ladner. On the Driver Training and Traffic Safety Advisory Committee, I recommend Blake Garrett and Carlos Reyna. On the Polygraph Advisory Committee, I recommend Sharon Brink. On the Speech Language Pathologist and Audiologist Advisory Board, I recommend Dr. Tammy Camp and Kimberly Ringer. And on the Towing Storage Advisory Board, I recommend reappointing Amy Milstad. Commissioners, you have those before you now. I would make note of the comment made by Mr. Barrett. These two appointments that we have, reappointments, are due to the fact that whenever this program was brought over to us, they had a 2-year term. So it was my opinion, the reason I'm reappointing them, my opinion was that they were just now getting up to speed on our programs and being over at TDLR, although they understood the industry, but being here with TDLR. So that's the reason I'm recommending them to be reappointed for a full 6-year term as opposed to the 2-year term that they had. So at this point in time, I'll take any questions or a motion would be in order.
I have a comment also. I kind of would like to agree with him. I think it's nice that if we can get some fresh blood on our advisory boards in the future, that we make the effort to kind of have, you know, other people come in and be able to be a part of the system and experience it, as well as bring a different perspective to the table.
And I cannot agree with you more. I would also ask that if anyone's listening from any different industries, those out in the audience, if you know individuals that would be great to serve on these advisory boards, either in the industry or as a public member to some of these boards, the most difficult position that we have to fill on these advisory boards are public members. We have a slew of public member openings right now on various advisory boards. At this point in time, we have 32 advisory boards. Is that correct? So 32 advisory boards that fall under the umbrella of the Department of Licensing and Regulation. So while we are always looking for fresh blood, the problem is sometimes we just don't have it. And so I would also ask commissioners, if you know of anybody that would be interested in serving, that you send them our way, have them go online and fill out an application and notate their interest in serving, either in an industry that they are in or as a public member if they would like to serve. So it's duly noted. I appreciate that.
Mr. Chairman, if I can add just real quickly, I appreciate the effort that you made in coming down several meetings over the last couple of months to go through the hundreds of applications. I also want to commend Nick and his staff, Tamala, Delia, and Christine. They did a fantastic job of weeding through it, and Mary Winston in helping with the evaluation of the applicants. At this point in time, once the commission takes its vote, we will now have new expirations. So, for example, the 3 positions that were available for the driver education position, you filled 2, so now there is a new vacancy, so not all the folks that could have come up for reappointment were. And we'll send out that email to the group, and Mr. Barrett makes a valid point that we'll ensure and endeavor to make sure that we get the information to those folks who already have applications on file to update that, to let us know that they're still interested in it.
Brian, how are we communicating these openings? Are we posting it? Is it an email? Or
It goes through our email notification. You know, we have about 800,000 folks that are subscribed to it. So whenever there's a vacancy, we send out that notice to that specific page. We also contact the different associations. There are several folks here that represent associations that we reach out to them to get membership. And even just recently, Commissioner Figueroa, we made contact with the Texas Association of Counties because we have had difficulty in filling the public members. And they have some judges and folks in their group that I think would be great members as public members to those boards. So we're trying to do the outreach, but it's primarily through our email notification page, and then it's also published in the Texas Register.
It just seems to me to be more of a hand-to-hand combat thing, because I think in the age of emails, I blow through those emails like as fast as possible. So if we could take it to Mr. Barrett's point, I think it'd be great
Absolutely.
to have some sort of aggressive campaign so that we can get these things filled, because they're our eyes and ears on the ground.
We can definitely add it to our repertoire when we're out there at the different association meetings. Like today, I'll be leaving shortly to go speak at the Texas Academy of Audiology, and I can remind them now that there is a vacancy on their speech language pathology group, and we'll do that.
And that's a good point. I appreciate you speaking on that, Commissioners, that there are various industries and associations related to these industries that we try to reach out to, but even at that, there are others that we try to think outside the box in order to be able to reach out to some particular associations that you may not normally think about. As an example, on the tow truck advisory, there is a position for law enforcement with counties above $1 million and below $1 million. So we try to reach out to the Sheriff's Association, the Police Chief Association, those type of things. So, and try to see if there's anybody that they would think of that would be interested in serving in those capacities. So we do try to reach out, and of course, we can always do better. So we'll make sure that we continue to evaluate that. So, any further questions, comments?
I move to accept the appointments.
We have a motion and a second to approve the appointments and reappointments. All those in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, Commissioners. We do have meetings that we're trying to get scheduled for after November 1 for some of these new programs, so these boards are imperative to have in place. Okay, let's now move up back to our contested cases. Let's go to item F1, Daryl Narcisse. Come on up, sir. To staff, I apologize, you're going to have to be on standby until you realize or understand that maybe your case is not going to come up, so I apologize for that, but unfortunately, this is how we have to do it. Go ahead and have a seat, sir. Charlotte, go ahead.
Thank you. Charlotte Melder, good afternoon, or morning, Chairman Ayers-Mendez, Commissioners. This case is fairly straightforward. It's an auctioneer who failed to pay a seller within 15 days. He did pay. He wrote a check, however, that check bounced. He did not realize that it bounced. It took a year or two for the department to be involved for the seller to get paid. Intent is not required in this. The judge did find that we proved the violation and recommended the $1,500 penalty, which is the lowest for this violation.
Any questions for Ms. Melton? Mr., is it Narcisse?
Yes, sir.
Is that correct? If you don't mind, state your name for the record.
My name is Daryl Narcisse.
Mr. Narcisse, was this wasn't ALJ. So this was a SOA hearing. The only thing that can be brought before this commission are those facts and testimony that was held at the SOA hearing. So anything outside of that, our general counsel will step in, and also the prosecuting attorney will step in to say that that was not a part of the record. And so the commissioners are not allowed to be able to listen to anything that's outside the record. So if you can confine your comments to the SOA hearing, that would be great. All right?
Okay, sir.
If you don't mind, go ahead. Let's take your name for, I'm sorry, you already did. Go ahead.
Well, I'm not understanding what you're asking me to go ahead and do.
I know that you're here on your case.
Yes, sir.
I assume that you do not agree with the
Judgment.
with the judgment that was brought forth by the administrative law judge.
Yes, sir.
This is your opportunity to tell the commissioners as to why there was an error in the AOJ's decision and how they came about that.
Okay.
And
Well, I was hired to conduct a estate sale for a gentleman who was removed from his property by the state. And in short notice, his son was given authority to hire someone to liquidate this estate. In the process, it took actually 15 sales. During this process, I issued this gentleman 5 separate checks, and this, which is being contested right now, was the last of the checks to finalize this sale. Apparently, Mr. Gango made an attempt to deposit the check before a credit card machine allowed it to process through the system. And after doing so, he did not notify me in a timely fashion that I could correct it, react to it, and do anything about it. Subsequently, I had went out of business more than a year later and never was contacted by Mr. Gango or his wife or anyone from their estate. And the first notice I had was from the Texas Department of Licensing and Regulation that there was an issue. Once I was notified, I took care of the situation, made sure that they were paid through the Texas Department of Licensing and Regulation, and as a result, the department determined because it carried beyond 15 days that I should be assessed this fine. I was not responsible in this instance for the fact that it took beyond 15 days. The person that made the complaint didn't notify me whatsoever, and even in the letter that they sent to the Texas Department, it wasn't dated. I never received it, but once I was informed about it, I took care of the situation.
Any questions for Mr.?
So has the person that was injured in this transaction, have they been made whole?
They have. They were paid in full. And it's common for us to dismiss in situations like that, but the complainants really wanted to go forward because it took so long and they had to go through so much to try to get paid.
And how long and how much trouble?
Well, it was December of 2014 when the check bounced, and they were paid, I believe, earlier this year, or 2017. So,
Took over 2 years.
but again, I understand he was talking about the time in between.
Well, their monies was in my bank account until the point that I went out of business, which was a year ago, January. And I hadn't been notified by them even up to that point. They have my phone number. They knew I was in a location. They could have dropped by and told me we had a problem, but I didn't know. And once I did know, according to what I understand now, apparently they didn't know. And once they found out in their checking account records, it was beyond 15 days, and then however long it took them to know, they contacted the Texas Department of Licensing and Regulation to contact me for whatever reason rather than them contacting me themselves, because my phone number is the same and everything.
When did the people that were injured in this situation, when did they notify y'all?
Earlier this year.
Earlier
It's not
this
that
year.
old of a case.
Okay, so how quick was his payment from when?
He paid within 4 months.
Any other questions?
Do you still, are you still in the business of doing auctions?
I am still a licensed auctioneer, but I have not conducted business since
Right.
this is going on. So I am technically out of business, and I reestablished myself as an auctioneer using my home address as business, but I haven't sold anything at this point.
Was there any evidence in the case of the injured person contacting you, Ms. Norris?
There was a letter, but again, it was not dated. There's no evidence. There is evidence in the file that they did realize that it bounced much later than when it had bounced when closing out an old account. And then they notified him, but there was no evidence because the complainant couldn't remember when they realized that.
I'd like to make a motion.
Just a second. Mr. Narcisse, were you not notified by your bank that the check bounced?
Well, according to bank records, once she told me, I went to the bank to find out when this happened and so on. Apparently, this happened approximately 2 days after the check was written, and my process of going day to day, I didn't notice it through my bank account because I don't do all of that reconciliations all the time myself. And so it wasn't brought to my attention. I didn't know. And even at that, once the money was there, it was good. And all I kept realizing was that these people hadn't recovered their monies. And I never made an effort to contact them
Why not?
because as a fact that they had a check written to them and they had family issues. So
But why did you not make an attempt to contact them?
because I had did my part, I gave them a check, and I thought that whenever they decided to cash it, it was good because
But they did cash it 2 days later.
I didn't know that because the money appeared to be in the bank.
But my
And,
question is,
Yes,
that you
sir.
would have been notified by your bank that there was a return check fee.
well, if you're saying notified by my bank, like call me and tell me,
No,
I
I'm just
didn't.
talking about notification by the
If
bank,
you're saying
either
through the mail
a-
and so on, I never saw it.
You didn't see it on your bank statement?
I don't reconciliate my bank statement as timely as maybe most people do, because it's,
Well, and that's fine, I can understand and live with that.
Mm-hmm.
But the moment that you noticed that there was a return check fee,
I never noticed it. I never noticed it until then.
so did you go 2
I
years
went
without,
back to
did you go 2 years without reconciling your bank account?
Well, as it stands, I had other issues with my treasure auction situation, but I reconciliate according to what I understand to be proper methods, and I've always balanced generally. But like once this situation came up with the checking with the credit card machine, I had never used one until this situation came up with Mr. Gangle. He wanted to be paid by credit, so I went and allowed him to get it and agreed that he would be responsible for it. So with this credit card machine affecting my bank account, I was always confused about what was going on. So I made efforts to contact my bank frequently about things that was going on that I didn't understand, but that part never came to my attention whatsoever.
Okay.
And the family wasn't aware either,
Right,
so they didn't realize that they never got repaid.
until much later.
What is much later?
The best we could determine was between 8 months and a year after the check bounced.
8 months to a year, okay. And so, Mr. Narcisse, did they contact you? Do you have any, can you give me a timeline about when they contacted you? So even though it wasn't dated, when was the first contact you got? Was it from TDLR?
From TDL&R.
That was your first notification that the check had bounced
That
and
it
that
was
they
a
were not paid?
situation, yes, sir.
Okay. Any other questions? Because I believe Commissioner Yurko has a motion.
I would move to adopt the PFD and reduce the fine to somewhere between $250 and $500.
I second the motion.
Okay, so is it
250 or
250.
250, okay. So we have a motion and a second to amend the PFD and decrease the fine to $250.
Yes, sir.
All in favor signify by saying aye.
Aye.
Those opposed? No. Motion carries 3-1.
Always do that when you know it's going to pass.
Thank you.
Motion carries 3-1. Do you understand what happened?
I do.
Okay, they'll get with you, but we reduce the fine to 250.
Thank you, sir.
So-
Mr. Narcisse, if you're going to get back into this business, be careful.
Yeah.
There was a
We'll hire an accountant.
That was hard necessary to learn.
I don't want to see you back here, okay? You were given a gift today.
Thank you, sir.
Don't come back, okay?
You're not the bar.
All right. I have no one else here for cases and motions for rehearing, is that correct? You have a case? Did you fill out a form?
I've got one, but I'm on the agenda, so I'll just read it.
Well, okay, but I need you to fill out a form in order to speak, if you don't mind. Do you have a case also?
I have a case, sir.
Yeah, the forms are up here, if you don't mind filling out the form. Which one are you with, sir?
Sir.
What's your name?
Keith Campbell.
I believe that's a motion for rehearing. This is Brad Bowman.
Okay, let's go on and move on to the motions for rehearing. Item 8, G8. I don't know who has that case.
Doug, Mr. Chairman, Doug
there
Jennings
he is.
from our office is going to present that.
And, yeah, go ahead and have a seat up there.
G8.
It's in the motions for rehearing.
Good morning, Chairman, Commissioners.
Go right ahead.
So we are on the Campbell case?
Yes, sir.
Yes.
Okay, making sure, thank you. Doug Jennings, Assistant General Counsel for the Department. This is a motion for rehearing that arises out of a default order in which the Department assessed administrative penalties against the respondent totaling $7,200. Based on the respondent's alleged failure to maintain proper documentation, to include certain required information in its notification letters, to keep records at its principal office, and to send the required initial notice within 5 days to owners and lien holders. In his motion for rehearing, the respondent alleged that he provided the Department with requested information and documents and had taken corrective action to address the alleged violations. And we find that to be true. From our review of the materials, it looks like the department staff requested respondent to provide them with certain documents, including templates of notification letters. And on several occasions, via both email and postal mail, the respondent sent that information in, wrote the department, and it just does not appear that our staff responded to the comments. As you'll see, this would have been the respondent's first violation, and there's a high likelihood, I mean, there's no certainty, that the case would have been settled, if the communication had been effective. And so in this case, I took the initiative here to speak with enforcement and determine if this would be a grant, even though there's technically no error alleged in the motion for rehearing. I did just see some inconsistencies in our communication with the respondent that I felt should be addressed. And so my recommendation, or our office's recommendation, is granting the motion to allow the parties to restart the process and perhaps settle this case.
Okay. Mr. Campbell, you heard what he said.
Yes, sir.
I don't know if you actually want to speak or just kind of leave it at the way it is.
I was ready, but either way, we need to do it, yeah.
Well, it's up to you. If you want to speak, fine, but you know what the general
Yes, sir.
counsel is saying, that
Yes,
their
sir.
recommendation is to go ahead and grant the motion for rehearing.
Yes, sir.
Would you like to speak, or would you like to have a seat back where you came from?
We can leave it at that.
Okay. Then I'm going to go ahead and
Good
just,
man,
Handed
good
it
man.
to-
I'm just going to mark through
Good
this.
move.
So, yeah. So, Commissioners, we have a recommendation by General Counsel.
So
General
moved.
Counsel.
Second.
And motion second, all in favor, signify by saying aye.
Aye.
Those opposed, motion carries. There you go, you're good to go.
Thank you, sir.
Staff will get with you, and they'll talk to you about the next steps.
Okay, thank you.
Which case are we working on over there? Motion rehearing? Benitez? Okay, so this is actually a case. Okay, it's item F5.
Chairman, if I may, just for continuity purposes, I don't know, whatever your prerogative, I know we have one more respondent in attendance on the motions for rehearing.
Who's that?
And we do have another recommendation of grant, Mr. Nguyen.
Mr.
Nguyen.
Your recommendations?
Okay,
Who?
is that Nels R. Us?
Yes,
Also, he was here.
yes, but I'm happy to step away if you.
No, let's go ahead and take care of that.
Okay.
Is he in the audience? Where's he at? Back there? Okay.
Yes, he is.
So they didn't fill out a form, but go ahead, let's do that one right quick.
Okay. Tuvan, would you mind?
And Mr. Chairman, this is Brad Bowman. I think we were unclear about whether the respondent wanted to testify.
Does he
We do
want to
have-
testify? Ask him if he wants. Okay, just go ahead and have a seat then.
And we do
Oh.
have a translator from customer service available to
Right,
help.
but that's fine.
Thank you.
Since he's here, let's go ahead and just take this case up so he knows.
Okay, thank you very much. Again, Doug Jennings, Assistant General Counsel. This matter resulted from a default order in which the department revoked two of respondents' cosmetology licenses based on his alleged failure to pay any of the $3,000 penalty in a previous case. And the previous case resulted from a failure to maintain disinfecting logs and to a failure to disinfect certain equipment. The respondent has entered into a payment plan with the department, has already made a $750 payment of the $3,000 balance, and has committed to making 9 monthly payments of $250 beginning in November. And because of the existence of that payment plan, we have a recommendation to deny the motion for rehearing, but to probate the revocation of the respondent's 2 licenses for 1 year. At the end of the year, if the balance is paid in full, we would dismiss the case. But obviously, if payments are not made, can bring proceedings to revoke the licenses.
So moved.
Second?
We have a motion to second. All in favor, signify by saying aye.
Aye.
Those opposed, motion carries. Thanks, Doug.
Thank you.
You don't have any more? do you?
We have one more grant. I don't think the respondent is here, but,
No, we'll take those up later. Talk
okay.
about that.
All right, will do. Thank you.
Yeah, I'm only going to take those up of individuals that are actually here right now.
Thanks.
All right, let's move on to item F5, John Manuel Benitez. Mr. Sims, you'll be the only one speaking?
Mr. Benitez is also present, Your Honor.
Okay, is he going to speak?
Don't know yet, but maybe.
Depends how it goes?
Yes.
If he does, he needs to fill one of these out,
Okay.
just so you know.
F5.
F5, yes, sir. I did tell you I'd be skipping around.
Cases.
It's in the cases, yes. Mr. Sharp, proceed.
Good morning, Mr. Commissioner, or Mr. Chairman,
Same thing.
Mr. Chairman of the Commission. My name is Ken Sharp. I'm an enforcement prosecutor with the department, and the respondent in this case is John Manuel Benitez. He applied to renew his incident management tow operator license. The administrative law judge recommends that you deny his application for renewal and revoke the license. The respondent has the following convictions: 1995, assault with bodily injury and resisting arrest; 1996, 2 different counts of theft; 2005, 2 different counts of assault with bodily injury, family violence; and then in April 2015, he was again convicted of resisting arrest. That charge arose when the respondent physically resisted police officers who were trying to arrest him for driving while intoxicated in a tow truck, which incidentally he was also convicted of. He had collided with a utility pole and 4 parked cars, drove on the wrong side of the road, and then entered a shopping center parking lot where he crashed into one of the businesses there, which disabled the tow truck he was driving. Police responded and had to physically subdue the respondent. They took him to a hospital where a blood test showed that he had methamphetamine, cocaine, and marijuana in his system. And then afterwards, he told police officers that his tow truck had malfunctioned, and that's the reason he couldn't stop it. The ALJ misconstrued the department's pleadings in the evidence and also the relevant law with respect to the respondent's false answer to his criminal history question on his 2015 renewal application. He had falsified his 2015 renewal application by denying that he had been convicted of any new offenses, although he had only 4 months prior to that application. Because of the egregious nature of the offenses, including DWI and a tow truck, the ALJ concluded the respondent's renewal application should be denied and his license revoked. The department asks you to adopt the PFD but revise it consistent with the department's exceptions to include as a basis for denial and revocation the fact that he falsified his 2015 renewal application. Thank you.
Any questions for Mr. Sharp? Mr. Sims, I do have a form also for Mr. Benitez, but I believe at this point in time, you're unsure whether you want to speak or not, so we'll have it just kind of on standby.
Yes, sir.
So, Mr. Sims, if you don't mind, state your name for the record.
My name is Jody Sims. I represent John Benitez.
I'm not sure if you've been with before, but as you heard me say in one of the other cases, we can only take in consideration those items that have been brought and testimony has been brought before in the SOA hearing. Anything outside the record, you will be notified by either general counsel or a prosecutor that that was not submitted as a record item in the SOA hearing. So just want to make you aware of that. Proceed.
Yes, sir. Members of the commission, I would characterize this as a fairly well-contested hearing down at the SOA. The SOA judge made some findings. Mr. Sharp objected to those. The SOA judge addressed his objections, and to my reading of it, overruled all of them. I would ask the commission to sustain the overruling of his objections. He didn't like the way the SOA judge heard the facts. And specifically, SOA judge said, I'm not going to find that Mr. Benitez falsified a record based on one mistaken statement in an application. I think the SOA judge was the credibility of the witnesses, saw Mr. Benitez, listened to his testimony at the hearing, and determined the man made an honest mistake. In the proposed disposition, the SOA judge, I think, correctly sets out the law that this isn't a shall suspend case, but certainly the commission may suspend. So the question is, should you suspend? The SOA judge came down and, I guess, recommendation number 13, or number 8, said that Mr. Benitez has not established that he presently has the fitness, honesty, integrity, and trustworthiness sufficient to support his continued license. We submitted a couple of exhibits. A letter from his employer was admitted into evidence from the person he's been working for over a year now. down in San Marcos. That letter from his employer specifically says that Mr. Benitez is, it's hard to find people like him in this, says he is honest,
Was
hardworking.
that submitted in the hearing?
Yes, sir.
Okay.
But he specifically refers to the honesty of Mr. Benitez and says he's an honest person. You know, hasn't stole from him, hasn't. Also, at that hearing, we submitted I believe it was Respondent 6, and I'd like to substitute the original, if I could, for the documented, exhibited, or at least show it to you that, I don't know what, I do criminal defense work. I deal with police officers all the time. The chief of the police of Johnson City wrote, John Benitez, date of birth, and his family have been living in Johnson City, Texas for approximately 4 years. During this time, John, not Mr. Benitez, or this guy, during this time, John has been a productive citizen in our community and has had no negative contact with the Johnson City Police Department. If you have any questions or concerns, says where to call him. He signed that. And I would submit to you that I don't know that I could get a letter from the chief of police saying that I'd done anything. And he didn't just say, don't know him, hadn't had no contact.
Well, you're an attorney, sir, so.
Well, that probably rules me out.
Well said. So you're on a roll today. You're on a roll, Mike. You're on a roll.
Also, I would submit to you that since this has come up, yeah, Mr. Benitez had a bad day, a really, really bad day, but he stepped up and took responsibility for it. He pled guilty to the DWI. He went through all the treatment that's in the SOA judge's recitation of the facts and summation of the facts. She spoke how he finished his probation, did all the classes he was supposed to, and the judge made the observation that Mr. Benitez had been punished. Economically, job-wise, he was making $100 and some odd thousand a year here in Austin. APD, towing and enforcement, booted him off their list almost immediately after the arrest. He had to leave town. He lost his home. His kids had to leave private school. Life was pretty good for Mr. Benitez, and he went to Johnson City and started making it again at a substantially reduced rate. We introduced his W-2s, showing how his income went down by probably 70 or 60%. All of this is in the summation of facts that the SOA judge wrote. She reached the conclusion that his fitness, honesty, integrity, and trustworthiness, that he had not established that sufficient to support his continued licensure. I respectfully disagree with her, and I would ask the commission, at some point, this man has demonstrated 2 solid years of not getting in a bit of trouble, and from what I can gather, the investigators they have, they know whether you washed your hands when you left the restaurant or mouthed off to your 4th grade teacher, and they've not brought anything to that SOA judge that since they started this licensing procedure, that Mr. Benitez has so much as spit on the sidewalk since he got his probation and finished his probation, did his counseling, and dealt with his alcohol and drug abuse issues. Certainly, as I said, this commission can suspend, revoke, do whatever you want to do, but you're not absolutely required to. It's a discretionary thing. And Mr. Benitez is here this morning asking that you exercise that discretion, give him a chance to continue as a tow truck driver. If the commission wants to put conditions on it, that he be ordered to inform the San Marcos Police of your action, that he be ordered to inform any company that he works for of his situation, that he submit to random UAs, whatever the commission feels, something short of taking his complete livelihood away, where, as the SOA judge found, he'd been doing this for 17 years.
Any questions for Mr. Sims? Mr. Sims, I do have a couple of questions. I think that when we can start looking at the criminal history of Mr. Benitez, it dates all the way back to 95.
Yes, sir.
We have 95, 96, 2005, and then the recent cases that occurred in 2015. So we had a period of 10 years where there were no offenses, and then all of a sudden we have an offense, which in my opinion is an egregious offense, of just an arrest and DWI, while my understanding he was driving a tow truck.
Yes, sir.
Is that correct?
That's correct.
So now you come before us and you're telling us that despite that, he should still get his license.
I'm asking the commission to consider that he received treatment, extensive treatment,
And I am commending him for that.
and as opposed to, in Travis County, he could have gone and sat 30 days in jail, got 2 for 1, 3 for 1, been out in 10 days, 15 days, probably at the most. And instead of that, he served his entire term of probation and went through his counseling, went through his classes, and hasn't been in trouble since.
And in Travis County, if he had done that, he probably still would be before us today. Is that correct?
Yes, sir.
So it doesn't change the fact that despite going through that from a judicial side and the court side, there would more than likely have still been a case against him for the DWI while driving a tow truck.
Yes, sir.
And you're asking us to allow, or you're asking this commission to allow him to get his tow truck license back while the last offense he had was in a tow truck.
Yes, sir. That's what we're asking today.
Okay, well, I find it very difficult to be able to do that. Just kind of so you know. Commissioners, any other questions?
I've got a quick question, and this may not matter, but I just want to understand. We gave him a license despite 95, 96, and 2005.
That's correct.
Latest conviction was 2015, or latest offense was it?
These offenses occurred in March of 2014.
2014.
That's right. And then the conviction was in,
2015.
I think that's what it was, 2015.
August
Yeah,
2015.
right. Yeah, I think June, maybe. There's some other information that I wanted to give you, too, whenever you've finished with Mr. Sims.
Okay, I'll come back to you. Any other questions for Mr. Sims? Mr. Benitez, I don't know if you wish to speak? Yeah. You would? Okay, come on up. I think you probably heard what I told Mr. Sims, is that we can only take into account that testimony and evidence that was brought before on the SOA hearing. So if you don't mind, move the mic over to him, if you don't mind. So just keep that in mind. If you don't mind, state your name for the record.
My name is John Benitez.
Okay, proceed.
Just like you guys to know that I made a mistake, and I was in my tow truck, and it was my tow truck. I was a contractor with a towing company. I wasn't working. I was driving home in my tow truck when this incident happened. So even though I was in the tow truck, I wasn't actually working in the tow truck. It was my tow truck. I drove it home every night, you know, and I was on my way home when this did happen. So that's all I would like to say about that. And I'm really sorry that it happened, but I am trying to move on, so.
Well, Mr. Benitez, I can tell you, I commend you for at least standing up and taking responsibility of your actions.
Yes, sir.
Unfortunately, sometimes our actions do have consequences.
Yes, sir.
And those consequences can be lingering. Those consequences can end, which I don't know the way the commission will go today, but there will be a point in time when you can reapply as a tow truck in the event that the commission chooses not to grant your license. If they choose to grant your license, you'll walk out of here able to do that. So, all I can do is tell you that there is hope at the end, but just understand, I do appreciate the fact that you're willing to come before this commission and sit here and to tell us that you are taking responsibility for what you did.
Yes, sir.
Any questions for Mr. Sims or Mr. Benitez? Thank you, folks. You can sit there, or have a seat back where you're at, just up to you. Ms. Sharp.
Thank you. Well, I wanted to say, well, first of all, I wish our investigators were so prescient as to be able to divine persons' bathroom habits or unseemly expectoration, but they're not. They don't know everything that happens. I wanted to say that our job here is not punishment. We don't do that. Our job here is, as you know, is consumer safety and public protection, and that's what we're here for. We're not here to punish anybody for anything. That's something that they have criminal courts for, and so we're glad we don't have to get involved in that. With regard to Mr. Benitez's claim that he simply made a mistake on the application, he was convicted 4 months prior to completing that application. The application asks if he had been convicted of any misdemeanor or felony. He explained that he thought what they were asking for was whether he had been arrested. Okay, well, he was arrested in March of 2014, and in his 2014 application for renewal that happened after his arrest, he didn't report it there either. So I think it's a bit disingenuous for him to say that, I thought I made a mistake because I thought they meant arrests, but then he didn't do it there either. So either way, I mean, I just wanted to explain that perspective, that he simply made a mistake.
Okay. Commissioners, any questions for either Mr. Sims or Mr. Sharp? Thank you. You can have a seat back. Commissioners, motion to be in order?
I'd like to make a comment.
Sure, go right ahead.
Mr. Benitez, I'm glad you're staying off the drugs. I'm glad you're not doing alcohol. I'd like to commend you for that. I'll be praying for you. I hope you do well. Having said that, I make a motion that we deny his license,
To adopt the PFD.
to adopt the PFD as recommended and deny the license.
We have a motion.
Second.
Second. All in favor signify by saying aye.
Aye.
Aye. Those opposed? Motion carries. Mr. Sims, Mr. Benitez, you'll be contacted by our staff. There are other administrative remedies that you'll be able to seek out concerning this, and they'll be able to explain that to you. So it's not over yet, unless you want it to be, but you do have other remedies that you can follow. Thank you.
Excuse?
Yes, please. Is there anyone else here for a case or a motion for rehearing? Okay. Commissioners, what I would like to do is to take a break for about a 10-minute break. When we come back, we will take up the Tnc Rules and get started on that, because despite the fact I'm sure you're not all here because we're here on YouTube, I think you're probably here for the Tnc Rules. So we'll go ahead and take that up after our break. So let's go ahead and take about a 10, 15-minute break. It is now, I'm going to say 10 o'clock, and we're actually 9:59, but we're now coming back to our meeting. We are going to jump to item K, which is the proposed rules for the transportation network companies. This is a new program that was brought over to us after this last session. I believe Governor Abbott signed the bill May 29th, is that
Yes, sir.
correct?
May 29th.
So that program came over to us. We were fortunate they gave us some time to be able to draw up the rules, which we now have before us today. I do have a litany of comments. If you see what I have here, it's more like a batting lineup, which I made reference to that to Mr. Lucetto. So why don't we do this? Why don't we go ahead and start lining you people up and getting ready for comments. We have Homero Lucetto up to bat. We have Paul Tommy on deck, and then we have Tim Joyner in the hole. Okay? Just so you know, all the comments, we do have a 3-minute limit, which I'm sure you guys are used to, having testified before the legislature. We have a 3-minute limit that we're going to limit you to. So what ends up happening is that if you go past that, that particular seat has got a trap door. You'll be notified by Kay Mahon over here, and she'll let you know, and you can find your comments to 3 minutes. We would appreciate it. There's a lot of discussion on this item, so we'll kind of start from there. Go right ahead.
Thank you. First, let me say I appreciate the sacrifice that you all are making by serving. As a Texan, I will tell you that it's always appreciated where Texans step up and are willing to sacrifice their time away from their families, their businesses, their communities, et cetera. So my name is Homero Lucero. Commissioners, thank you for allowing me to testify. I appear here on behalf of the Texas Commercial Airports Association by comments on proposed rules for HB 100. I would like to thank Brian, Charles, and Michael for their work. I think it's a compliment, but I told Brian it's not flattery, it's a statement of fact. So we continue to work with them, and we thank them for all the work that they're doing. In brief, TCA member airports serve more than 135 million passengers annually. They support more than 968,000 full-time jobs and produce more than $107 billion in annual economic impact. I'll say that again, $107 billion in annual economic impact. The association respectfully reminds the department that airports are governed under Title 49 of the United States Code and must continuously provide the U.S. Secretary of Transportation assurances that revenues generated are solely expended for capital operating costs of airports and are directly and substantially related to the transportation of passengers. The Title 49 accountability standard greatly surpasses any the state could set, and coupled with preemption of federal rules and regulations, TCAA recommends striking all of 9510. Now, these comments are based on the previous rules. We just reviewed the rules this morning. We acknowledge some of the work that's been done, but we still believe that this to be the case. Further, Title 49 requires state airports to be as financially self-sufficient as possible, reflecting the unique, local, individualized federal infrastructure requirements for Texas airports. One airport is not like any other airport. So therefore, they need to reflect that unique, local, individualized infrastructure. The purpose of the self-sustaining rule is to maintain the utility of the federal investment in Texas. The accountability standards apply to generating revenues, including those for both aeronautical and non-aeronautical. These revenues collected are from air carriers, tenants, concessionaires, lessees, and airport permit holders making use of airport property. The FAA's auditing requirements far exceed and would continue to exceed any included in the proposed rules, whether the initial ones or the ones provided today. Additionally, 9510 does not reflect the language where an airport and a TNC must enter into an agreement for data sharing. Data collection will ensure uniformity and non-discriminatory application, ensuring compliance to airport rules and regulations pertaining to all TNCs as well as all other modes of airport transportation. Data collection is necessary to ensure that all TNC trips are accurately accounted for, as well as for terminal curbside management, which is vital for both operational and public safety responsibilities of Texas commercial airports. I pause to say simply that we live in a new paradigm. 9/11 created a circumstance that the airports had to become hardened. Those hardening rules are not done. there is contemplation, I visited with Brian about this, that the White House Office of Domestic Policy is considering hardening to the curb. That means the TSA screening will believe the second you get out of your car. I have some other comments that are included in my presentation, but I thank you for that, and that concludes my testimony.
So, Mr. Lucero, you're saying that we need to strike all of 9510?
Yeah. Yes, sir.
And 9510 is in, for those who don't have it, is in reference to fees established. And it also states, I believe, if I'm not mistaken, the reasonable fee would be consistent with the FAA. Is that correct? With the methodology used by the FAA.
Sure, and the expertise that you need to make these decisions will be provided to you by the airport specifically. But in terms of the point that we're making overall, is that the FAA has a standard of accountability that is so much higher, and it's based on federal law and, of course, case law that's developed as a result of that. That the grant assurances, that is money that the federal government invests, that's primarily what the feds are looking at, maintaining the integrity of that process. So we believe 9510 is a threat to that.
For the grant assurances.
Yeah. And by the way, when we're talking about grant assurances, we're talking about, in Texas, we have two major hubs, and we have two major airlines that are attached to those hubs. These airports are economic engines, so you affect them in one case, the ripple effect is much greater. The economy as a whole, as it relates to Texas, is dependent upon those airports, because the passengers that are driven here, once they get off, they spend money, and you all know this, because you guys are going to do this every day. You're talking about airports, you're talking about hotels, rather, you're talking about car rental vehicles, you're talking about retailers who depend on y'all doing retail therapy, you're talking about restaurants, you're talking about liquor. All of that is affected by what may be contained in these rules. So the ripple effect is much greater than just simply the airports.
And I understand, I mean, we have, I think we try to be very conscientious of that.
Understood,
not only
and
with this
appreciate
one,
that.
but because of the other rules that we have underneath the umbrella. But this particular rule does not prohibit TNCs, and for lack of saying transportation network companies, I'm just going to say TNC, that TNCs would be, can mutually enter into a data sharing with the airports. Is that correct? If they both agree to it?
A cursory examination of the proposed rules, because I didn't get them until this morning. I would say to you that on reading that, that's the case, but that doesn't negate the point that I'm originally making. As a result of attempting to put into statute what already is at the federal level, which will be preempted, I mean, it'll take precedent over the state rules. So it's an area that may not necessarily be in the best public policy making decision. So that's where our position is from the association's perspective.
Any questions from Mr. Lucero?
So just the conflict between the federal and state level is what point? What exact point are you seeing?
It's the accountability.
No, but what metric or what criteria of accountability?
It's the airport compliance program, and it dictates within there what is permissible.
But you see this rule as in conflict to that?
Yes. Mhm.
In what point? What specific? Give me a specific.
It attempts to substitute for federal regulations specifically related to revenues. For example, diversion of revenue, that's prohibited by the feds. So the airports, when they get audited, have to show the revenue stream, if you will, and have to provide that information. Again, going back to the grant assurances, because the feds are investing, federal money, investing in that infrastructure in Texas. So it's the contradiction, the tension that the federal rules will preempt, or the federal statute would preempt, Title 49.
But the rules as they're proposed allow for airports to receive an audited report.
Permissibility, I don't think undermines our viewpoint. Just because it's permissible doesn't necessarily mean it doesn't contradict with the federal rules.
You see revenue diversion. Is that what you called it, revenue diversion?
That's what the feds call it. They want to ensure that the airports don't take revenue and divert it for purposes other than it was intended. And again, the member airports will provide you with more details on that. But that's the compliance program. That's one of the overarching principles.
Mr. DeCero, is there a particular item in 9510 that you see as diverting grant monies?
It's the proposed rule in general.
Do you think there's a market-based mechanism to generate those funds and that are separate and apart from grant money?
Well, that's a good question, but let me answer it this way. Fair market value is a very, in terms of saying that what happens in one airport can happen in another,
Yeah, you can't, yeah.
so I think it's problematic to even begin that discussion, because where do you create an equation, if you will? Or is there a quadratic equation that allows for the interpretation of all these different variables across all these different airports? You know that Corpus,
The market could kind of figure that out.
the market does figure that out, and that's related to the individual airports being allowed that authority by federal statute. So just to finish the thought, what happens in Corpus Christi, as you know, is different than what happens in Love Field, what happens at Hobby, or what happens at DF, or even the smaller airports, the one in El Paso or the one in Killeen. Individual markets are dictated by local circumstances, correct? Just like construction costs are dictated by local circumstances, you know, depending on the cost of transporting the materials, the number of individuals that may be available for construction purposes. So that's the reflection of each individual and the decision of each individual airport. Again, it's the feds that permit that under strict guidelines. And so that's why I would say the original answer is 9510 just contradicts that.
But the FAA takes into account the various geographical regions and various economies of the locations of the airports.
By permitting each individual airport to have that decision, that responsibility.
And you're saying that 9510 does not allow that?
I'm saying 9510 contradicts the spirit of Title 49. And by eliminating it, we rely upon the federal statute, which again creates a higher level of accountability because of the federal dollars invested in those airports.
But under B1, it says establishing using a fee-setting methodology for airports, which provides for a self-sustaining and market-based fee consistent with guidelines published by the FAA.
So I would answer it, so this one is more personal in terms of, if we're talking about fixing prices, that's a new area that most of us wouldn't particularly see as something that we would welcome. So from that perspective, again, the feds are the ones that, and I don't want to belabor the point, but I think you guys have already gotten it. Again, going back to the 9/11 example, those are circumstances that changed, and because of that, those requirements were based, or the FAA allowed those airports to determine what was necessary individually at their individual locations.
Okay. Any other questions for Mr. Lucero?
Again, thank you, appreciate it. Look forward to working with you on this. I think it's a tremendous opportunity for all of us to continue to work. Thank you.
Thank you, appreciate it. Paul Tommy, is that correct?
Yes, sir.
If you don't mind, state your name for the record.
Paul Tommy.
Go right ahead, sir.
Thank you for the opportunity to comment, Commissioners. For 20 years, I have been privileged to represent Dallas-Fort Worth International Airport as legal counsel, and for an even longer period of time, Dallas-Fort Worth International Airport has been pleased to host the headquarters of one of the world's largest airlines, American Airlines. So I'd like to kind of give you a small window into our world. Airport finance is a zero-sum game. By both federal law and airline use agreement that we have with the airlines, if our non-aeronautical revenues fail to cover their costs, the airlines have to make up the difference. Every dollar we don't collect from TNCs or taxis or terminal concessionaires is one less dollar that goes to support the landing fee for the airfield. That means it comes directly out of the airline's pocket. Hypothetically, if this regulation were to cost us $10 million in TNC revenue per year, that's $10 million more that the airlines would have to pay us in landing fees. And at DFW, because American has 80% of the landings, they would pay $8 million of that money. So this does directly affect airline rates. And for that reason, it comes squarely under the federal revenue diversion rules, which include the requirement that for non-aeronautical uses, we must charge fair market value. Now, as the regulation was originally written, it gave us basically a choice of going back to whatever we were charging on May 29th, which I think, given the context that the regulations were still in the process of being made, is kind of irrelevant. But it also gave us a choice of a cost-based fee, which simply is directly contradictory to the idea of fair market value language. Now, we appreciate the staff's genuine attempt to bring the proposed language in line with federal regulation. I'm told that the new language in 9510 B2 was taken directly from the revenue use policy. I have not yet had a chance to verify that, but it doesn't solve the underlying problem, and that is that the state of Texas should not be attempting to engage in airport rate setting at all. What's the point of paraphrasing a federal policy if the federal government has already staked out more or less an exclusive right to regulate this area? The airlines have spent decades of time and effort and truckloads of money to persuade the federal government to create this system of federal airport regulation and regulation of aviation. They were trying to avoid what they called the balkanization of aviation. They didn't want to be subject to 50 different rate-setting governing authorities. We understand the reluctance of the TNCs to be regulated by every community in the state of Texas.
Your time is up, Mr. Tommy. If you want, I'll let you wrap up real quickly.
All I would do is suggest that what we're asking for is that 9510 be deleted. I'm only addressing the revenue use issue, and we're suggesting that you should simply go back to the language of the HB 100. The term reasonable fee is adequate for state law.
Any questions, Mr. Tommy?
Yes, sir. Mr. Tommy, you want 9510 deleted as well, just in whole?
In whole. 9510A1, although we appreciate its acknowledgement that we have to comply with the ground assurances, if the rest of the rule were taken out, it wouldn't make much sense for A1 to be there by itself. As for A2, dealing with the tracking data, it should be gone too, we believe, for reasons that I have not yet addressed, but other airports will. Primarily, I'm focusing on subsections B and C, which regard rate setting. And again, I'm simply saying it's been federally preempted.
So,
I'm sorry, go ahead.
So, if there is a deficiency, you have to pass that on to your airlines. Is the opposite of that true, though? If there's a surplus, do y'all keep it? And
well, we're not allowed to accumulate large surpluses. Bottom line is we're more or less a nonprofit entity. We're not allowed to make money in a way that would accumulate surpluses, but we're not allowed to lose money either.
Sure.
By federal regulation, airline costs, the airfield, are based on historical costs. But if we don't have the revenue from our non-aeronautical sources to cover roads and parking garages and all the other things that relate to ground transportation, if we don't have the money to cover the terminals, we've got no choice but to put that on the landing fee.
Sure, sure.
And that's just...
And our task is to make sure that it's fair for everybody, the consumer. You know, just Joe Texan.
I understand the motivations behind this regulation, and we sympathize with them. There are market forces that prevent us from just going hog wild and charging whatever we might like. There are other ways to get to the airport besides taking a TNC, and if we charge the TNCs too much to provide that service, we'll start losing money. So we have to be aware of what the market requires us to do, and it doesn't make sense to tie it to a cost standard. In fact, it contradicts federal policy to tie it to a cost standard, and the danger is that if you wind up capping the fees we're allowed to charge any non-aeronautical user, if it's capped too low, it runs the risk that we have to pass that on to the airlines, and then it becomes something that affects the cost per enplanement, which makes it difficult for us to attract new air service to Texas.
Let me ask you a question. It's funny, the balkanization is kind of happening to these TNCs anyway, not to airports, but is there a model anywhere else in the United States that you see that works better, or that is one that other states should look to?
Well, I think this same conversation is going on in different states
God bless you.
because Texas is not the only state that is attempting to preempt local regulation of TNCs. And again, we understand the preemption game. We sympathize with TNCs. But the fact is that when it comes to airport rate setting, as opposed to city or county rate setting, airport rate setting is federally preempted because it does indirectly affect what we have to charge the airlines. And that puts this whole discussion squarely in the crosshairs of the federal supremacy clause of the U.S. Constitution, and it just guarantees a lot of litigation that none of us want. Bottom line is, it doesn't make sense to layer a state layer of rate-setting regulation on top of an existing federal layer of rate-setting regulation.
Understand.
Mr. Tommy, I guess you're alluding to the fact that if these rules don't go your way, there will be litigation that we have to face.
I can't say that for sure, but I would imagine that if the airlines start losing millions because the non-aeronautical revenue has fallen off, there would be a heavy incentive for them to file a complaint, and that's how these things happen. The FAA Inspector General doesn't come do a daily bed check to see if we're in compliance with our grant assurances, but when somebody makes a complaint, that's when they do the deep dive.
Based on your knowledge of HB 100, what do you believe precipitated this particular legislation?
Well, probably frustration. Probably frustration.
If you could keep your comments to yourself out in the audience, please.
Probably frustration by the TNCs that they were having to deal with 300 or 400 different set of regulations at the city or county level. No business likes being micro-regulated like that. The TNCs have enough influence in this state that they're going to be heard when they have to be regulated at that level. We understand their desire for state preemption, but when it comes to airports, the federal government has already said dibs.
And I understand that, and I think that it's my understanding that the rules that are proposed are a attempt to ensure that the FAA still is not being contradicted.
Well, we respect that, but if paraphrasing federal standards is all the state regulation is going to do, then what's the point of having the state regulation at all? First of all, the federal standard might change someday. Is the regulation going to change accordingly?
Well, and are the rules not written in a manner that would allow for the changes to take place?
The changes to the local regulation?
To the
No,
state
no.
regulation?
I assume you can change any regulation you wish.
Well, yeah, we as a body, as this authoritative body and the ability to adopt rules, can make changes at any point in time to any rules and any program that falls under the Texas Department of Licensing and Regulation. My question is if the FAA makes changes to their rules, does it not automatically kick in with the proposed rules that are before you?
Well, I wouldn't think so as written. I was informed that this language in B2, or is it? It's the cost language in the rule. I'm told that was taken directly from the federal policy dealing with non-aeronautical rate setting. Now, if the federal policy somehow changes, maybe they decide it shouldn't be fair market value, or some other way of defining fair market value, that's going to put this at odds with federal policy, and we're just going to have another round of regulation making.
Well, we're pretty nimble, sir. We can move.
I have no doubt.
We can make changes.
I have no doubt. But what is the point of regulating an area that the federal government already claims exclusive regulatory rights over?
Okay. And I understand your concern on that. But it was my understanding that this was an attempt to not be in conflict with the FAA rules.
That was the obvious intent of inserting this language. I have no doubt that your staff has acted with great diligence and good faith in attempting to address this issue. But the problem is, the issue can't be addressed by paraphrasing federal policy. It gets
So would
back.
it work better if we just actually put the policy in here, or refer to?
It would work better if you simply defer to HB 100 and say airports can charge a reasonable fee, period.
And reasonable is?
Whatever the FAA says it is.
So I go back to the same question. If we inserted the language of the FAA, would that suffice? Or make reference to the FAA rule?
Well, what would be the need for that if all you're doing is saying reasonable fee? Reasonable fee is pretty broad.
How do y'all assess it now on taxi companies? How do you assess a reasonable fee now?
On what we think the market will bear, because people will find alternative means of transportation. Clearly, we do consider costs. We have to consider costs in everything we do. But ultimately, we have to have the discretion to set rates based on what we think will serve the public.
Is this not an alternative method, though?
The TNC, would that not bring rates down for everybody, allowing multiple options here?
What would bring rates
Uber,
down?
taxis, all the TNCs that we're we're
Well,
talking about.
That's a distinct possibility, and let me be clear about one thing. We're not opposed to T&Cs at the airport. We embrace innovation. We compliment them on the fact that they have found a new and innovative way to grab market share. They didn't create the market, though. The airlines created the market, and the airlines guard it like a pit bull. And if the rates that we charge any non-aeronautical user doesn't collect everything that the airlines think they're due in terms of having costs not shoved onto them, they will file a complaint. And at that point, it becomes a federal matter.
And the complaint would be lodged against TDLR.
No, it would be lodged against us. They would make a complaint that we're charging them rates we're not entitled to charge because we're failing to collect from non-aeronautical users what they think we should be collecting. That would be the complaint.
So, am I assuming that you would defend us?
Absolutely.
So I guess to me, in my simple-minded attitude, is that there's revenue and profitability. It's just about because who gets it? Is it the revenue? Is it going to be the TNCs, or is it going to be the airlines? Who gets that? Because you're the pass-through agent, basically, because you're non-profit, if you will, for lack of a better word, net zero status. But your backstop is the airline, correct?
Yes.
So that profitability moves somewhere. The dollar doesn't disappear. It's got to go somewhere. Does it go into the airline's pocket, TNC's pocket? Whose pocket does it go into is what we're...
Well, if our non-aeronautical costs are not covered by non-aeronautical users, then those costs are going to default to the
Right.
landing fee.
But the petition is this, as a God-loving capitalist, right? Innovation is the key, right? So when innovation or price market doesn't push something, by definition, it stagnates, right? So even operation of airports, right? I mean, I go through them now. You guys, I got iPads instead of waiters. You know, you're more efficient, more lean. I've been to the terminal. It's a great thing, right? Which I think the kiosk is so innovation is motivated, in my mind, by that profitability. You take the profitability out, it becomes stagnation. So I guess my concern in this regulation, right, is twofold. One, we don't want to be biasness towards the airline or the TNC. We want to make sure that the citizens of the state are getting the best bang for their buck. Plus, there's a constant push in that process to create innovation, because we may have flying cars next time with airports. I have no idea, right? So that's my mindset. My constituents, or the people that I want to make sure, is the guy who just walks in, that lady who walks in that airport, is getting the best cab ride, safest cab ride, or whatever ride they get, and being economic without somebody going bankrupt, but also that they're being pushed for innovation, that there's not a... Does that make sense?
Yes, absolutely. We're not here to challenge state preemption of other aspects of regulating TNCs. It's merely the rate that we're allowed to charge the TNCs that we have a problem with. And federal government has already made a decision that airlines should not have to subsidize non-aeronautical uses of the airport.
I got that, but it's a very subjective process. What that means is who gets to pay for it, and then how do we push the airports to be innovative enough if they've just, if they're just where they are, if they don't move forward in their movement to be more efficient or cost effective.
Well, I have to brag about my airport. I think we
Go right ahead.
push ourselves pretty hard to be innovative.
Well, and that's
we
good.
want TNCs at our airport.
That's
We're
good. No,
glad
that's good.
they
But
came here.
we're on the same page with that. I'm just making sure as these chess pieces move, I understand the strategy behind it. And again, that's again, end game for me is the citizens of the state, right? That's my end game, to get them the safest and most.
Well, I would ask you to keep in mind that having two hubbing carriers in the state of Texas is good for the citizens of this state as well.
I concur.
They bring a lot of jobs, and they also bring direct air service from every continent on Earth. We've got people in Asia and Africa right now trying to bring more air service to our airport, direct air service. And one of the most key performance indicators we use is the cost per enplanement. What does it cost an airline per passenger to do business with us?
Sure.
And the more we can generate from non-aeronautical sources, the better we look to them, because that's much less money we have to get from them.
Right. I agree.
And just so you know, you're
good
preaching
pressure
to the
point.
choir.
It's just a balancing act. This is this is like a teeter-totter.
It is.
It's just-
And I'm not trying to discount your role here, but the simple fact is that when it comes to rate setting, airport rate setting regulation has been preempted by the federal government. And the mere fact that this is non-aeronautical rate setting doesn't take it out of their purview, because non-aeronautical rate setting affects aeronautical rate setting indirectly.
Well, the caveat's been in that place. I appreciate it.
Any further questions, Mr. Thomas? Thank you, sir. We have Tim Joyner up. Looks like Ted Kitchens is on deck and Ryan Rocha is in the hole. Go ahead.
Good morning, gentlemen and young ladies of the commission.
Oh, my God.
He's working it.
My name is Tim Jonick. Thank you for the honor of batting third today. I hope to bat better than our home team has been batting recently. On behalf of the city of Houston, I'm here to offer comments.
Are you related to Mike in any way?
On behalf of the city of Houston, I'm here to offer comments regarding TDLR's proposed rules governing TNCs. The city of Houston operates three Houston airports, of which two, George Bush Intercontinental Airport and William P. Hobby Airport, are commercial airports served by transportation network companies. The city acknowledges TDLR's proposed rules requiring that TNCs obtain statewide permits to operate in Texas. The city is concerned about, one, the ability of airports to assess reasonable fees for TNCs to use the airport, and two, the airports to have reliable tracking of TNC vehicles that operate at the airport. As you've heard from my colleagues, the city's airports receive federal funding from the Federal Aviation Administration, and as a condition, must charge fees to commercial entities that use the airport to allow airports to be self-sustaining. The city wants to be certain that TDLR rules do not prohibit airports from calculating fees in such a way that is consistent with federal law. I also want to request on behalf of the city that TDLR clarify that airports can require TNC vehicles, like taxi cabs and other commercial operators, to display markings identifying and indicating that they are a commercial vehicle. In other words, trade dress. Thank you for your consideration. I bear my other 1 minute and 30 seconds to my colleague, Mr. Kitchens, unless you have questions for me.
Well, I'm sure we will, and I'm not going to let you do that. So your concern, as you said, is the trade dressing, and which is not addressed in our rules. Is that correct?
That is correct.
But you're asking that we do have trade dressing.
Yes, sir.
And the purpose of that is just to simply identify.
Every commercial vehicle that operates at the airport has trade dressing and is identifiable as a commercial vehicle versus a general public vehicle that you may own or I may own that comes to the airport to do a pickup or a drop-off.
You want to distinguish just between private and public or public transportation vehicles, right? That's basically.
Purely, yes, sir.
Purely, that's it, okay. Is there a reason why we wouldn't want that? Is there something that I'm missing?
I'm sure that, well, you may be able to answer that, but I'm sure Charles will also address that too.
Yes.
And I don't know if you want to address that, but.
I defer.
Okay. And you also asked about the data sharing?
Tracking.
Tracking, I'm sorry.
Vehicle tracking.
Why specifically or would you want that? Just
A few reasons. Number one, gets back to the grant assurances. Are we collecting all the trips, if you will, that we're supposed to be collecting? The vehicle tracking will allow for that. Number two, we want to be able to be able to regulate our curb space. Curb space is precious. Curb space, if it's not patrolled properly, can lead to safety and security issues as well. And as a service provider to the general public, it's our responsibility to keep a safe front door, if you will.
And that's opposed to the entrance and the exit of a TNC vehicle, correct? Tracking says you keep track of them the whole time they're on your facility?
On airport property, yes, sir.
As opposed to just the entrance and the exit?
correct.
Do I understand that?
Yeah, you're correct. Tracking them on and off our airport property as opposed to not having any tracking mechanism whatsoever and relying on self-reporting of business at the airport.
Would y'all be comfortable with an independent auditor?
I think just complete tracking would be the preference. It's being done at many airports already across the United States. One of my colleagues will tell you about that shortly.
Okay.
They've lined this up, I can tell you. Do you currently, is there currently tracking provided for other third-party transportation companies?
Yes, sir.
So you're telling me that taxis also abide by the tracking, as do limousine drivers?
Yes, sir.
And I know you're probably only going to attest to the Houston airports, but are other airports doing it as well?
To my knowledge, other airports are doing the same thing.
But the two airports in Houston are doing that?
Yes, sir.
Any other questions from Mr. Jonick? Well, you got off easy. Appreciate it.
Thank you for the number 3 spot today. Thank you.
Mr. Kitchen's in the cleanup position.
Yes. To continue the baseball analogy, you guys are throwing some sliders here. I hope I can fend some off and get a hanging curveball. Since I am batting fourth. I tell you.
Did I miss something, Brian? Did we get comedian day today?
This is in honor of the
Astros.
Astros.
Are the Astros playing today?
Yes.
Play today. doesn't matter.
Houston strong, right?
Exactly.
They win today. They win today.
Yeah, they win today.
You don't mind state your name for the record,
Ted
please?
Kitchens, I'm the general manager at George Bush Intercontinental Airport in Houston,
Right ahead,
Texas.
sir.
So, good morning, Commissioners. Again, thank you very much for having the opportunity for me to submit some oral comments regarding the Texas Department of Licensing and Regulations proposed rules under the TNC program. I would like to also thank the TDLR for addressing some of the concerns that Texas airports have brought up and raised throughout the rulemaking process. However, my testimony is just going to address the rules as they were originally published, since we have not had adequate time to digest the new rules. I'm going to truncate some of my comments because I think my colleague Paul has done a reasonable job, a sufficient job in discussing reasonable fee, but I can elucidate on some of the questions. The FAA Compliance Office does have Part 16 challenge oversight, and that is the challenge process that Paul referred to. And usually grant insurance number 24, which is the grant insurance that covers having reasonable cost structures, is the number 1, if not number 2, most popular place for Part 16 challenges around the nation. So as my colleague Tim said, I'll talk about the tracking data. So I'm going to skip ahead here. We also urge the department to consider redacting, at least in the old rule 9510B2, which limits the airport's ability to track a vehicle. The final rule should allow airports to track TNC vehicles electronically and through visible trade dressing by submitting to electronic tracking requirements and identification markings on their vehicles, as it is today for all commercial vehicle operators.
What rule? What rule are you talking about again?
It was 9510B2. I don't know if that, it was in the originally published rule.
Okay.
Remained unchanged, so that tracking prohibition still doesn't.
So these tracking efforts and markings will enable airports to easily identify a vehicle for fee setting, again, assuring that we are getting adequate number of trips. Security purposes, I mean, airport curbs are very complex environments, very transient in nature, and having vehicles that are not distinguishable from private vehicles will inhibit our ability to effectively identify if somebody is on the curb that should not be on the curb. And of course, that creates a soft target and other security threats and or redress purposes. It should be noted that TNCs and our National Airport Trade Association, as Tim mentioned, are currently working right now together to enhance data sharing. Some of the airports that are included in that include San Francisco, Atlanta, Dallas. Medium hub airports, which are like on the size of San Antonio, would include Jacksonville and Anchorage. And small hub airports, which would be akin to a Corpus Christi or an El Paso or Lubbock here in Texas, are Memphis, Norfolk, Buffalo, Albany, Colorado Springs, and Northwest Arkansas. So House Bill 100 as written or Chapter 95 as proposed should not be read to put FAA funds at risk or prohibit airports from tracking TNC vehicles for fee setting, security, or redress purposes. And I would like to at least take a little bit of leniency here. And I would like to also recognize Brian Francis and his staff for the professionalism that they've extended to us throughout this rulemaking process.
Thank you. I appreciate that. Any questions for Mr. Kennedy? Mr. Kennedy, I do have a couple questions. You mentioned the trade dressing and the curb. The airports that I have flown into, there is always a designated area for TNCs, taxis, limousines to be at. Some of the airports that I've gone into, I know it's a limousine, but they don't tell me it's a limousine. It's not, there's no trade dressing on the limousine. Taxis, from where I go into, they're yellow. I know what they are.
Right.
But yet you're asking that the TNCs that the rules are proposed right now are asking for trade dressing, even though they are to designate themselves by parking there, because, you know, I can tell you in some airports, I'm not going to mention which ones they are, I have to walk a long ways to get to that area, to the TNC area.
Sure.
So why are we asking for trade dressing when you already have a designated spot for pickup?
Right, well, several reasons. Number one, maybe trade dress is a little bit too specific of a term. You know, when I think of trade dress, I think of the yellow cab, right?
Right.
Or the pink mustache or lift. Maybe it's more a distinguishing mark, you know, and it can be something as simple as if this year, you know, the permit that TDLR issues for cabs is a yellow sticker, and then next year it turns to a blue sticker, and then a red sticker. At least then our guys know, hey, if I see a yellow sticker and it's supposed to be a blue sticker this year, I've got somebody that's not permitted through TDLR on my curb.
But the permits are for the companies and not for the drivers.
Well, and I think it needs to go to the individual, not necessarily individual drivers, but the company needs to issue the sticker for that driver.
But HB 100 addressed the company as a whole,
Correct.
not the drivers individually.
Correct.
So you're asking us to reach down into the drivers.
To allow us to enforce our curbs,
Would that not be outside the intent of the statute?
potentially, yes, sir.
So we really don't want to do that, do we?
Well, that's your decision.
Well, and let me tell you that I find it ironic.
We just need some way that we can identify who needs to be there and who does not need to be on the curb.
But the curb designation itself is not enough.
No, sir, because we find, and this is the second part to my answer, we find, and I'm sure other airports can attest to this, that sometimes the drivers are what we call scooping. They're just coming straight to the curb, and they're just finding a passenger saying, hey, I'll give you an off-book trip for $15, and Uber doesn't see the money, Lyft doesn't see the money, Get Me doesn't see the money, Wings doesn't see the money. It's an under-the-table transaction almost. We see that in our airports.
Oh, really?
Yes, sir. They will bypass the geofence. They will do GPS spoofing, meaning that their car is over here inside the geofence, but the GPS is saying they're outside the geofence, so they're able to get a ride. They are very creative, very innovative. The drivers are extremely innovative.
And now, these are
in finding ways
drivers-
around the barriers.
But these are drivers that are not associated with any of the TNCs?
They may be.
So you're
we,
saying
we,
that-
we have drivers that have in our TNC lot up to 10 cell phones, and their friends are up the road, and when a match is made, the friend comes down the street, they throw the phone over the fence, and they go pick up the ride to the curb. That happens all the time.
If they could just put that power to good, man, that would be great.
Well, they are. I mean, they're making a living. But they are circumventing the rules. They're finding ways to get around the system, and that presents a security and also a curb management problem for us.
But I think that it doesn't matter what happens, you'll always find those individuals that are going to try to get around the system.
Absolutely.
So I think the rules that we put in place are for those that are willing to abide by the rules. Because it's difficult for us to be able to stop those individuals that are wanting to go around the system. So the rules that we put in place are for companies to hope that they would be able to abide by the rules. And if they're not, then they come before us and we can slap their hand, slap a fine, and do what we need to on our end to keep that from happening. But as you attested today of individuals that, in some cases that we had, that went outside the scope and committed a crime.
Correct.
The only thing we can do is slap their hand after the fact. So while I understand that those issues are alive and well, I believe that if the airports were able to solve that, then there'll be another issue they have to take on down the road. Because as you said, they're creative, and they do this. But my concern is for the companies, and only because of the statute that was written, HB 100, my concern is the TNC companies. We don't have the authority to reach down into the drivers. And I believe that by identifying them, we're now reaching down into the drivers, and that's not what the law states.
And so here's an interesting public policy issue then. So we have drivers that are independent contractors of the company. None of these are employees of Uber or Lyft or any of the TNCs. So therefore, Texas Workforce Commission rules and other rules say you can't direct or control the activity of the drivers. The state has taken away regulatory power from the city, and now the feds or me are the ones that are left to try to regulate this industry. And it creates a void where we are in a lose-lose type situation.
But you're asking us to enact rules
and certainly,
that are outside of our scope.
Well, but the city regulates and permits the individual TNCs, but we also gave airport use permits to each of the drivers. So we were able to do that when the city of Houston had the regulatory oversight. So we individually permit the companies, but then we issued, each driver had to come in and get a permit or an airport use permit or a sticker.
Right.
And every day we go through the lot today and we'll collect 10 to 15 that are expired.
Right.
So
Did
we
you
just
track
scrape them off the window.
Did you track those individually as they came onto your airport?
We do not. We have a geofence. They have to go outside the geofence and then they come in. But our tracking right now is we call up Uber and Lyft and Get Me and Wings, which are the 4 TNCs at Houston, and say, how many trips did you do? And we multiply it by our fee, and that's what we get. And you know, if you read Part 16, you read some of the FAA guidance. That is not a system that would stand scrutiny of FAA audit if they do come and audit.
So any system that we put in place would be better than what you're doing now, do you think? I mean, would you agree with that, or?
From a tracking perspective, yes, sir, it would be.
Now, there's made reference into our rules, May 29th of 2017, which is the date that the bill was signed by Governor Abbott.
Yes, sir.
Prior to that, was this a problem?
This being what?
Tracking, the trade dressing?
Yes, sir. It's been a problem since the inception of the program at Houston, at least.
And I assume that you guys addressed this during the legislative process to try to get that implemented into the statute.
Yes, sir.
I'm getting a big yes by Mr. Lucetto back there. So,
He's the expert on that.
yeah. Well, and I think that I can tell you that it's a conversation I had with the executive director and some of our staff yesterday. I don't think that the rules will, the statute will end. What will happen is I believe that this will happen. These rules, however they take place, will take place, and there'll be tweaks made in the next session, which means that we have to come back and tweak our rules. So I guess this is what they mean when they say job security for Mr. Lucetto. So, and while I appreciate the comments that you made and the words and everything that you brought to us, as my counterpart, Commissioner Figueroa, said that our concern also are the citizens of Texas, and to ensure that that they're protected, but that there's also that reasonable charge that they have. And as we know, in anything else, those charges are passed through. So as a retailer has an increase in cost, they don't absorb it, they just simply pass it through because they have to be able to make their margin. And so the consumer is the one that ends up paying that. So, and I hope that you appreciate the fact that those are the kind of concerns that we're looking at when we're up here talking. It's like, how is it fair to, in this particular case, the TNC companies, the cities, the airports, the constituents? We have to make sure that there's a balance between all that. And the unfortunate thing is that not everyone's always happy, either one of those parties. but we have to try to strike a balance between all that.
And I certainly appreciate that, and I appreciate the staff's efforts. And you're right, there's always going to be a pass-through, but that's to a point.
Sure. No, I understand.
Until
Because the
my
market
dollar-
forces do
yeah,
kick in.
I mean, let's face it, an economic exchange is just that. What you have is worth more than the dollar is to me.
Right.
And my dollar is worth more to you than what you have. So
Right.
we enter into an exchange. At a certain point, it becomes unsustainable.
And I do want to recognize the fact that at the airports that we have, that was mentioned earlier, the economic impact, I believe somebody said, was 107 billion economic impact. When you begin to start taking a look at that, and the ability for that to increase even more so by going out and trying to get more airlines to come in, it provides the ability for citizens of Texas to also be able to go to other places at a reasonable cost that they may not have been able to address before, because airports are doing everything they can to bring in additional airlines.
Certainly.
So I appreciate that fact. And by no means do we want to be able to hinder the non-aeronautical revenue that they realize and that they have. But again, I go back to that balance that we have to find. And I would commend the airports for what they do and ask that they continue to do it, because, trust me, I would like to be able to go to some different locations and not have to hop, skip, and jump everywhere I go to. So, I commend you on that, but this is a very, and I knew it would be, the moment that there was discussion about this coming over to us, that it was going to be a very hot topic. And that I hope that we can at least find a balance, but I don't expect that this topic will end anytime soon.
And the disruptive economy does that. It disrupts, but it also elevates. I mean, it allows for growth. It allows for new opportunities. And just as Paul from DFW said, we embrace that innovation. We are all for choice and as much choice as we can to all of our passengers, from air service choices to choices on ground transportation to choices on concessionaires. What we need to do, though, is make certain that you mentioned a galaxy of folks there, but we have taxis, we have super shuttle, ground transportation, multiple ground transportation.
Yeah, that's your
So
world.
we have to play and make certain that those constituents are happy as well.
Sure. And I appreciate that.
Sure. Mr. Kitchens, I'll ask the same question I asked Mr. Tomey. Is there a model that works at any airport that you like, where this has been struggled with and implemented?
As far as TNC rate making,
Has anybody been able to strike that balance that we're looking for today?
not to my knowledge, and from what I'm understanding from my discussions with FAA, there are some potential compliance issues that are being raised in other sections of the country about this very issue. So I think it's starting to get the attention and gain the attention of the regulators in D.C., and I don't know if we all want to go down that road or not. But it is something that is becoming known.
Okay.
And I think they're struggling with it as well, from my discussions with them. But I think, back to Mr. Tomey's question, or his comment, the best way to do it is allow each airport to do it, because the FAA has pretty much said, hey, we're going to step out of this. As long as you can show me that there's a system that is verifiable and you have structures in place and you have audits and you can show me that you are taking care of business, I'm going to allow you to continue to do what you want to do, because that is a decision. Not only is it a decision from our point of view, from what we want to charge from a cost recovery, if it's 100% cost recovery or 50%, that is an intensely local decision. That's a governing body decision to say, okay, if we charge 100%, it's going to be a pickup fee of this. Well, we don't want that. Maybe we do only a 70% cost recovery or whatever. As long as you can show that and you can defend that to the FAA, they are typically okay. As Paul said, they don't come do a daily bed check.
Sure.
And that's something that they look to us to ensure we have those systems in place, and that when they do come do the bed check, we have that in place, and we can easily show them that we're adhering to our own standards.
Thank you, Mr. Kitchens. Any questions for Mr. Kitchens? Thank you so much.
Thank
Appreciate
you.
it. Next up is Mr. Rocha, Ryan Rocha.
Vice Chairman Butler?
Yes, sir.
If I could just interject at this point, I'm going to have to leave at 10:54. I'd like to just make a few comments before I go, and Mr. Roach and I, we talked outside, so he said I can take 3 of his minutes and I didn't get him back. First thing I want to do is I want to thank Charles and Ford for doing an amazing job. Pauline goes unnoticed in this process. She did a great job. Brad, Nick, Carla, Colleen, and Pauline, Colleen, and Mary Winston also. Very quickly, the rules, as we've modified them for the commission to consider, you don't have an easy job. And there's no smooth cut down the middle for this Solomon decision. It's jagged. That's what we're dealing with. I believe that the language that we put in that overhanging piece and arching piece for Federal Aviation Administration guidelines, maybe it can be stronger to say it must comply as opposed to consistent with, must follow theirs. Those elements underneath, I think we took very dramatic steps to remove the conflicting language of cost of services study. That's out. We are deferring to the Federal Aviation's process there, and maybe there's a stronger point that we can do to that. On the issues of branding of the vehicles and the drivers, it's just very clear in the statute that we can't conflict with any of the regulations there, and specifically as it relates to the drivers in 2402.107. So we can't go further than that. The difference that we've made, the distinction we've made, is that there's a difference between to and from, and then monitoring what's the movement on. And that's where we draw the line on reporting of the to and from versus tracking. That's just how we arrived at it. That's our thought process, for good or bad. Just want everyone to know that. But I believe there's still some tightening of the language we can do to make very clear. Paul raised some great comments. We are not trying to undo the preemptive role of the feds, and that's why we made those recommendations. We may be able to tighten that language a little quicker and say it's FAA all the way, but I think we still have to put that in the rule so that the person is not privy to this discussion that comes in 9 months from now, understands what reasonable fee means in this context, and they don't have to sleuth it out because they weren't present for this discussion. I'm going to leave it at that, and we'll give all of your names and phone numbers of the commissioners, and whether you're going to be on a no-fly list after this meeting or unable to get a TNC, that's going to be on you. But
Brian, I have a quick question. When you said the comment about reasonable fees, how did you compare that with past organizations where we are doing it on a cost basis for what it costs the agency?
The reasonable fee language in this statute is completely than anything we've ever dealt with. Our cost basis that we typically look at is what is TDLR's cost of operating that program. Right. That reasonable fee language speaks to what can the airports assess to a non-aeronautical business, and we don't have that in any other program to where we've been invited in to the commercial enterprise of 2 other entities. We've never been there before. We typically just say, you're going to be licensed by us, here's what it's going to cost us to do it. Reasonable fee in this context says that airport can make the decision through FAA what they are going to assess to this non-aeronautical service called transportation network companies versus taxis, et cetera. So it's brand new ground for our agency.
So I'm confusing because I got the impression that we were changing that from the airports. Am I misunderstanding that we are more in line with what the airports was seeking?
Our initial proposal, it was clear at the October 5th public meeting that, and I have no problem saying this, we have learned more at every juncture in this. I learned more today about the business. But what we thought we knew on October 5th, the airports made a compelling case that we didn't know. We didn't know how much Chapter 49 governed the reasonable fee and the rate setting methodology for those. So after that October 5th method, we made changes and presented those to you that we do believe moves it in line and makes it more consistent in acknowledging that the FAA's guidelines, whether it's in Chapter 49 or CFR 200 or in the grant assurance information that Mr. Rocha provided to us, that we're deferring to that, saying at the end of the day, you need to be in compliance with that. That's going to be the standard. That's what reasonable fee means in our interpretation if the commission goes in that direction.
And then the to and from point you were talking about, I'm assuming the to is less regulated than coming from the airport?
The to and from is just simply saying they can get a number of the trips, whether somebody is dropping someone off or picking someone up, because if they get 2,000 trips, they're going to say 2,000 times the $4 per TNC doing a trip. They need to have some mechanism to know what that activity number is. We didn't have that initially in the first proposed rule setting, and by us saying that tracking was prohibited, it seemed to say they couldn't even get a report on what the activity was. And we wanted to clarify that, no, the airports can get that number, and they should be able to get that number.
Is that what was discussed by the legislature, that they wanted that tracked? Or do they want?
The legislature in the statute 2402 has language that says that airports, and I'm paraphrasing, Paul, don't you get me on that one, but the airports have language that, in the statute that says airports can have regulations relating to the to and from on their facilities. And so we lifted that language to make sure that we put it in our rules, and we had a provision that said, yes, they can have reports and receive reports that give them that data. Mr. Chairman, I'll be available by phone if things work out well. I will be out of phone service.
Understood.
You're in good hands with Nick and Carla.
When you leave, we'll make sure that everybody has your cell phone. Mr. Rocha.
Yeah, good afternoon. Thank you for having us out here today. I really appreciate your time. Brian, thank you and your team for your revised comments. We got a chance to review those briefly. Just by way of background, I'm the Chief of Operations for San Antonio Airport System. Been at the airport here for 10 years, 20 years in the industry. San Antonio Airport has a really good program for operating our ground transportation services. We serve about 8.62 million people in 2016, and that growth is continuing. We have about 300,000 TNC pickups just in the last 11 months. And this has been somewhat challenging for us because it's been difficult to really monitor and regulate the TNC activity. And of course, as you mentioned, Commissioner, it's a public safety issue for us, for our passengers. We really want to make sure we have some control on that. We have an increase of about 2 to 4% per month from our TNCs. It's been increasing very steadily. In fact, last month we have our TNC activity at 62% over taxis at 38%. So that number continues to grow. And we
repeat that, please.
Yeah, 62% of our traffic is TNCs compared to 38% of taxis when it comes to that mode of transportation. And it's been increasing about 2 to 4% per month. So all commercial operators, taxis, limos, hotels, all of them, car rental companies, all have some type of mechanism where we monitor them coming in and out of the airport. It's essential for the safety of our passengers. And so with that, it also comes with revenue accountability, and that's something we really look for, is making sure we do our part for the integrity of our collection. So we want to make sure that we collect that revenue. We want to make sure that we move out of the honor system, as which we have right now with the TNCs. It's a self-reporting mechanism, and it really is not a best practice in any industry to collect revenue at a commercial business based on an honor system. It really goes to the integrity of our operation and our reputation, and so we want to change that and make sure we're consistent with all the other modes of transportation. So what we've implemented back in July of 2017 is we implemented Gatekeeper. Gatekeeper is a software data sharing platform, and this is used at other airports all over the United States. And what we do is we track, through the data, license plate, date, and time. Those three things is all that information goes directly from the driver of the TNC to the Gatekeeper software, which is a third party, and then back to us. So with that, we're able to effectively monitor one of our TNCs on our airport in and out and have accurate information in real time. So we want to make sure we try to pass that along to the rest of the TNCs. So when we look at 9510, it really limits our ability to regulate those TNCs when it comes to data sharing. We want to make sure we have that capability. And we respectfully just ask you to really consider that 95.10 where it says you cannot compel data sharing.
Any questions, Mr. Rocha? I do have a question. So are you asking that the rules be modified to force TNCs to enter into the program that is currently being available by each airport? As example, Gateway?
For our gatekeeper at
Our
our
gatekeeper,
airport?
I'm sorry.
Yes, sir. At our airport, that's what makes sense for us and a lot of airports. Again, the challenge we have is we can't track where they're at on our property. So let me give you an example. We have a staging lot, right? And there's three components to this operation. There's the staging where they wait, there's the pickup, and then there's the exit. And our staging lot holds 80 TNC cars. And once it gets full, they go to other areas of our airport and they park there. It's out of their geofence. And what we can't do is we can't tell if that is a POV. We can't tell if it's a commercial business operator, TNC. So it's hard for our law enforcement to go and say, hey, are you conducting commercial business on an airport? If so, you need to go to the TNC staging lot. No, I'm just a pedestrian. I'm just a regular POV. Okay, well, you can't park here anyway. So we want to try to get some type of management on that, and we can't right now. We're in the dark. You asked earlier about the curb and how that affects us on the curbside when it comes to pickup. At our airport, we have the pickup location, because curb is valuable. We have it really adjacent to our POV pickup area. So we have the TNCs pull up, even though it says ride share only, we can't tell a POV from a TNC. You can't. Everyone has their mobile device sitting right up there, and unless the law enforcement officer knocks in every window, and this is 50 cars sitting there late at night, it's impossible to regulate POVs from TNCs.
You stated that if they go to an off-site location, that law enforcement will find out if you're a TNC, you need to move to another location or move to the TNC staging area. And if you're not, if you're a POV, then you can't park here anyway, so you need to leave.
Correct.
So is that not going to happen either way, whether the TNC or POV? I mean, the law enforcement is going to say, you can't park here, go, right?
The difference is it's commercial business. So it's still on our property, it's still our property, and we have rules governing errant parking. You can't just squat on a cul-de-sac. We can't have that.
But that's for
everybody. That's for everybody.
So
But
that's
especially
a law enforcement issue.
It is, and it's becoming a problem because what we have is a mix of TNCs and POVs parking where they want to park sometimes, and we can tell them, if you're a commercial business, go to the TNC staging lot. Okay, so officer will comply. If you're a POV, please go in circulation or park in the cell phone waiting lot. Two different areas. And so we want to make sure we have
But
that
they're both being removed from the curb.
Oh, yes,
or
they
both
have to
being
be
from
removed
wherever
by
they're at.
law, right. They can't just sit and wait there.
Has this been an issue with law enforcement? Have they addressed this issue? Because I haven't seen any comments concerning law enforcement.
Every airport's different. Our airport has a lot smaller footprint for space. It may be an issue to other airports, but definitely at ours, it is a problem.
Any other questions, or any questions for Mr. Rocha?
I appreciate you giving us some numbers, some facts to kind of go on. I mean, it seems to me that if the TNC volume is growing that much, that you want to do everything you can to increase it, right? I mean,
We thoroughly enjoy the TNC operation. It brings a new dynamic for our passengers. Some choose, and it's their choice. They either take taxi or TNC. They can take a shuttle bus. There's all kinds of ways to use ground transportation, and we embrace it all. It's just a matter of how do we effectively manage this new entrant, the TNC, just like everybody else. They have to play by the same rules. We can't exempt one and have a different set of rules for one, and the rest play by the rules. It's very difficult that way. And it's really a reputation issue for us more than anything.
Have you seen the spread between the taxi and the TNC's fees? Did it shrink lately, or have you seen that?
So I'll give you some background. In December of 2016, our rates were $1 per trip for taxis and $1 per trip for TNCs. We changed our rates to $1.25 for taxis and $1.50 for TNCs. So we do see rate increases.
But why? Why wasn't it treated equally?
Oh, the taxis have a dedicated orange light facility with a restroom. They have a lot of activity that they do there. And so that was our rate-based setting based on capital expenditures we already made. It's already a long expenditure we've had with the taxis. It's all decisions made by city council. It's not made by the board.
That's not what I was asking. Why are the taxis being charged less than the TNCs?
It's what the market rate bears. It's market-driven.
But you're saying the taxis' use is dropping and the other one's going up.
Those were set back in December 2016, and it's grown exponentially since then. And our rates, our rates are actually lower. Our rates are really low for TNCs compared to other markets.
So you're talking about, when you say market-driven, you're talking about across the airports, across the United States, right?
I'm talking about, yes, the market drives the activity of those operators.
You make the market in San Antonio.
Say again?
You make the market in San Antonio.
Well, I don't make the market. The people make the choice to make the
Well,
market.
the airport does.
Yeah, we set our rates based on our cost of expenses, our operating expenses. It's cost recovery. That's how we base our rates.
So do you have a staging area for TNCs?
We do, but it's not, it's a makeshift type of area. We had to find space to put them in. And that lot, when you talk about rates and why we set them, it's cost recovery. How do we base it? We got to do markings, we got to make improvements. These are the type of things we got to do to.
So the taxis have a higher quality lot, correct?
We've invested a lot of capital in that many years ago.
And they're being charged less, though.
Well, they charge 25 cents less.
Yeah, and the
But that-
TNCs doesn't have all the
25 cent higher.
restrooms and everything, but they're being charged more.
25 cents more, right? Because we're making recent improvements into that area.
Okay, so.
So you're
The
building
rate,
up
the
fund
rates are
to-
different because we made capital investments a long time ago for taxis, and we're making recent improvements now for TNCs.
So when were the rates changed from $1.25 to $1.50?
They
Or
ch-
those two?
They changed in December 2016.
When were the capital investment done for taxis?
Over the last 5 years.
So you're just now charging them for that?
No, we've been charging them. We've
But you just
increased
said
it.
that the rates were changed to $1.25.
They were from $1.25
So-
to recover a lot of that cost.
So you're just now charging the taxis $1.25 for it?
Yes, it went up 25 cents.
And you're charging TNCs $1.50 for renovations that you haven't made yet?
Renovations we have to make.
Okay, but you haven't made yet, you're going to make
Well,
them.
we've made a few. We've made a few to that lot. We've put in,
So you understand what I'm asking here, is that you're saying that you've invested all this capital, and you're just now charging taxis, and then you're collecting the money to make the changes down the road for TNCs?
sure, understand it's cost recovery. You're building in those costs.
Well, the
to make
the cost recovery was from the taxes. The cost recovery is not with the TNCs yet.
We will make
I know you
improvements.
will. What I'm talking about right now is you charge $1.50, and you haven't made those cost expenditures at this point in time. You're in the process of collecting that and doing that, but they're being charged right now, where taxes are being charged after the fact.
Okay,
Okay, so is that a correct statement?
sure.
Okay.
Okay, so 310,000 in the last 11 months, and 62% of that is TNCs. And so I did some quick math. That's 192,000 pickups, drop-offs. At $1.50 is $288,000, right? Okay.
Any other questions for Mr. Roach?
I just want to make sure that, I think there was a comment earlier that as long as everybody plays by the same rules, right? We don't want TNC to have an advantage over taxis. That's fair. We don't want the inverse to occur as well, right? So when you see discriminatory, the question, I kind of backed in that question, by the way. I'm not that smart, so I was going to tell you. But the question I was asking is more on the aggregate of the fee, right? Typically, the claim was that taxis are more expensive than TNCs. That was the typical. Have you seen those squeeze closer together of late?
But there's more fees to the taxis than just that. They still got to pay a departure fee.
Okay, I'm just talking about, just look at aggregate. I'm a client, I'm walking in the airport, I walk out, if I, $20 for the taxi, 15 for the TNC. Is that now 16 for the taxi, 15 for the TNC? Or that was the claim that I understood, that was the big disparity between a taxi versus a TNC.
Okay, taxis have a pass-through, so there's a fee. That $1.25 is our fee to them. It's called a pass-through.
Right.
They have their own fee that they charge for taxis. Let's say you're going downtown. A taxi could be more expensive because of a pass-through fee of $1.25 we collect, but they have their own rate that they charge. A TNC is a flat rate. There's no pass-through.
There's no mileage increase or anything to it.
Unless they do a surge, but I don't get into their
I guess I'm
business.
asking you a more macro question on the industry itself, so maybe I'm not doing this right.
Okay.
Have you seen the disparity between the total charge of a TNC trip versus the total charge of a taxi trip, on average, from your airport, become more in line with each other, or have you seen them spread apart on cost basis? Or it just depends?
I think it depends on where you're going. If you're a short trip for a taxi, it's a different rate than if you're a long trip. They have different rates. And they also have, I believe the TNC has different rates based on the surge, which are time of day, demand. So they have those escalators.
Okay, so we don't have that number, we don't have that fee, we don't know.
I don't have their fees. I don't know their numbers. No, I don't know their numbers.
Okay.
And that 125 and 150 discrepancy, is that something that's set by the city of San Antonio?
The city council.
The city council
Yeah,
sets that? You have no, you just collect
Well,
it?
well, it's set because we make recommendations.
Okay.
And we discuss it. You've got TNCs, taxis, everybody in the room, and everyone says their piece, and then the city council makes a decision on where the rate should fall.
Sounds familiar.
Okay.
Any other questions?
Thank
Mr.
you
Rocha?
so much, Mr. Rocha.
Yeah, good job.
Thank
Great
you, sir.
information.
Appreciate it.
Thank you.
Tim Smith.
My name is Timothy Smith. I represent the city of Dallas, who operates Dallas Love Field. Now that he's left the room, I want to answer Mr. Butler's questions. With regard to the matrix that would work to establish a rate, there is none. My airport's nothing like Houston. It's nothing like San Antonio, nothing like my big brother, DFW. For example, prior to the Wright Amendment, we were just rocking along about 4.3 million employments a year, doing a great job. Wright Amendment went away. We had a 2-year plan. In 2 years, we're going to start building another parking garage. Well, that Thanksgiving, we ran out of parking. We're doing a little over 7 million employments now in this short period of time since the Wright Amendment went away. So we don't even know what our market is yet because it's so dynamically changing. So at the risk of the baseball analogy one more time, we really don't need any more umpires. Quite literally, we are sitting between a rock and another rock. We are a department of the city, which is mandated by the city council, and we've got the airlines. Trust me, the employments are the canary in the cave. If they start dropping, they're going to be all over us because we did something to tip the scale. So there's no harm. We too want to protect the citizen. There's no harm going to happen. Nobody's going to go crazy with rates because we decided to try to recover some of the lost revenue. Our deregulation, the fees and fines that we got off of that help pay for the law enforcement. Right now, I have to have off-duty officers every night of the week from 8 until 11 just to handle traffic. We only have one road in, and that's the road out. We have no staging lot for TNCs. But I will tell you this, we're happy to have them. Prior to the TNCs, the taxis owned the curb, which is the prime real estate. When the TNCs came in, we started seeing things shift, and the numbers were getting crazy. Today, we're averaging 2,000 pickups, TNC, on our curb to the 600 of the taxi. That used to be the other way around. So the gap is widening, it is not narrowing. The rates are, as my predecessor spoke, they are dynamic, they change throughout the day. If it's just like if you're at the bar and you need a ride home, your Uber ride is going to be more expensive than it was to get there. That's the way that works. And that's something that taxis can't really do that. But we just, I had one more point.
Go ahead, wrap it up real quick.
With regard to the tracking, that is critical for my situation more than practically any other. I need to know what's coming in, just like that air traffic controller in the tower. He needs to know what planes are coming in so he'll know how to space them out. I've got to have that just to be able to manage the curve.
So you said that you've got 2,000 pickups by TNCs as opposed to 600 for taxis.
That's correct. That's an average every day.
That's an average every day. So that is, my math fails me right now, the percentage of that has got to be 60% also?
Maybe a little higher, yeah.
Well, actually, yeah, you're right, it would be higher. With the airports that are here, just by a nod I'm assuming that your TNC pickups are a much larger and increasing rate than taxis?
I can feel their heads going up and down.
Yeah, exactly right. Okay. Well, because we know San Antonio gave us numbers of 62% were TNCs. Yours are much higher.
They are.
So, okay.
And it really creates a problem. I manage my taxis with my queue, but that was built 10 years ago. There's no more land. We're landlocked, and there's no place to put a TNC queue. So they are wrapped around on side streets, and I got no way to watch them. I'm hoping to get gatekeeper so that I can see what's coming, because that's how I handle my public safety issues at the curb. And they are significant financially.
And I just did a quick math. Yours is 77%, so it's even higher. Are there plans by Love Field to construct a staging area?
Well,
They've been discussed? I'm just asking.
Unfortunately, all the property we have access to is owned by people that really want a lot of money.
Prime real estate.
We're trying now to create another entrance. If we can create another entrance, that'll give us a safety gap, and maybe we can do something there.
Out of curiosity, so even though the taxi share has dropped, do they still have the prime real estate curbs? They still
No,
have control of it?
that's the beauty of this. We saw very quickly which side our bread was buttered on, and much to their chagrin, we moved the taxis back. They're in position 2, where the limos used to be, and it's about 240 feet of curb right at the terminal. It's all TNCs, and it's like bees, it's just buzzing all the time.
Is this gatekeeper program, I mean, how does it help you manage what's at the curb as opposed to just a revenue toll kind of mechanism? I mean, really, is that what it is? It's just a toll?
If we had it, what we would do with it is, yes, we would audit that aspect of it. But more importantly, we would put it up live. We have our own police unit at the airport. We would put it up live on the screen so they could see where all the TNCs are. And when they start wadding up, and they do cause traffic problems. And that's when we have to pull people out of other parts of the airport to the curb.
And I assume that's during peak times of the airport.
Yeah. Right now, we're taking off-duty officers from another district and trying to get them in there.
Mike, you said something about we can't reach into the driver. Is that what you said? But trackability's already out. I mean, to make a mistake, I'm tracked because I've got toll tag. Right, so trackability is not even an issue in my mind. If you have a toll tag, you're tracked.
Right.
Good, bad, or indifferent, all over anywhere you're at. So I guess I'm trying to reconcile in my head, what's the big deal? Ticket or statute?
Well, and it may not necessarily be that for this one reason. If we're talking about regulating the company and not the driver, well, guess who knows where that driver is? The company does. That's how you're getting your information on your app. You don't have to reach down to the driver, just reach down to the company and say, you need to provide this to the airport.
And I think one of the interesting aspects for me is that, you know, I have a toll tag in my vehicles, but it's only for Harris County. And so when I come to Austin and I take the toll road, I get a nasty letter from the city of Austin or whoever it is that.
Oh, literally.
But for different reasons.
And so, we have an opportunity here to statewide level to do something.
We had the ability to track that toll tag under regulation, but now we can't. They don't have to give it up.
Because the statute prohibits it.
Because the statute prohibits, yeah.
Well, there's our answer.
But
If
that's
the
a toll
statute
tag.
prohibits it, then we
That's
cannot
not the
create
same
it.
thing as data sharing, though. All we need is the data. See, Gatekeeper talks to the TNC and says, open up your information, we'll collect it and deliver it to the airport.
So if you, I don't want to solve this tonight, but today, but if the toll, all you want is the toll tag to tell you how many times that TNC vehicle came into the parking lot.
Well, I don't need the toll tag to do it, their app does.
But the honor system is
Yeah.
that was the idea. We want a more formalized
Right.
third party.
But ours is not just for financial reasons. Ours is for logistical
Safety, I'm
reasons.
with you. But you evangelized me on that, but I'm just trying to figure out the methodology in concert with the spirit of the statute, right? The information isn't so much how fast the guy's driving or whatever. You just want to know when he hit the airport and when he left, when he came and how many times, so you can tell.
You got some smart people over there and probably figure out a way that this becomes a company issue, not a drill down to the driver issue. Their app that they get from the company
Right.
knows where they are.
Right.
That's all I need.
In a real-time way? Is that what you're saying?
It is absolutely real time, just
Okay,
like
so
your
you-
Uber app is. We see the same thing you do with the gatekeeper. Only we see everybody standing on the curb, waiting on all of their cars, and see where they're coming from. As soon as they get inside the geo fence, which is our.
And do you have a full-time person monitoring that?
What
Is
will,
there somebody there, like in law enforcement, or your
we have
traffic
a,
management people or something?
we have our own miniature, like other airports, we have our own little miniature police department, and yes, it's all in their operations center. It'll be up on a monitor all the time.
Wow.
And I guarantee you that the ground transportation manager that works for me, he will have it in his office up all the time too. So he can route people.
And it's a pretty neat system. I don't have the adaptive one, but in my previous position as city manager, we used to track the vehicles, and I could pull it up on my screen, and I would know where exactly every single
Yes.
vehicle was at.
That's exactly right.
It's a tracking system.
And because of the,
But we did it for 911 purposes to know exactly where people were at, so we knew who to
You don't have
dispatch.
facial recognition, do you?
Yeah, that's a question they're going to bypass.
but if I may, just for Mr. Butler's, because he stepped out, there is no model that says this will work here, this will work there. It's all different. And if we're not careful here, we can cause harm by creating a constraint on the airport that doesn't need to happen. Because, like I said before, we've got enough umpires on the field. I mean, I got the city council on one side, and I got the airlines on the other, and then the FAA is looking over everybody's shoulder. It's not like we need somebody else with their finger on the pulse. I mean, that's all. We just, the way 9510 is written just doesn't work for us.
Just in all fairness, I am a football official, so I'm going to really not take offense to what you said. All right, any other questions?
Thank you so much.
Thank you, I appreciate it. The last one we have a comment for me is on Johnny Bond. Mr. Bond, if you don't mind, state your name for the record, and then you can proceed.
My name is Johnny Bond, although I feel like John the Baptist crying. We've been talking about fares. We haven't talked. I understood that you guys don't have the scope for drilling down into getting into the fare for TNC drivers as well as taxi drivers. And my position today is that at 88 cents per mile versus $2.25 per mile, TNCs charge 88 cents per mile. The cab drivers or cab companies charge $2.25 per mile. This is where you're getting this flip of more TNC driver pickups than you have taxi pickups. Well, what I'm seeing is, because I've had the opportunity to work for cab companies as well as TNC companies, what I'm seeing is this giant suction of the cab companies being put out of business, essentially, because the fare is so imbalanced. And it needs to be addressed because in 1956, DuPont versus the United States determined that when you have a competitive rate that's already established, and cab fares are established rates nationwide as well as statewide, and when you have a competitive rate and that rate, and there's an entity that comes in and undercuts that rate, that competitive rate, then you're establishing a monopoly. So what we're seeing here is we're seeing the beginning of state regulation involving are more or less creating a monopoly for a TNC organization to eliminate the cab business. And what we say is this: the cab driver is picking up non-Android and non-credit card customers. They're picking up cash customers. They're picking up landline customers. They're picking up disability customers. They're picking up all of these customers that are going to be left out of getting transportation if you put the cab companies out of business. I'm appalled that no more than just myself is here as a cab company or cab driver representing the taxi industry, because they're getting ready to get slaughtered by the TNC industry. So I'm pointing out that the FAA has been overlooked by the state rules, so as the city council mode, the city council model is being overlooked because city council regulate fares for taxis. The state should be regulating fares for TNCs. The rate for a TNC organization, because they are specialty service, they are a specialty service. They don't serve the masses. They only serve Android phone customers and cash customers. And credit card customers.
Time.
Okay. So what I'm saying is the fair rate, to be fair, for TNC services should be the same or greater than the taxi service. Thank you.
Thank you, sir. Appreciate it. Are there any other individuals here to speak on the TNC rules? So, I believe you do have a form that you're filling out or have filled out?
I have a form that Brian Francis lost.
You say that because it's not here, right?
And you'd like to call him and ask him to verify that, I would be more than happy.
He's a big guy. You sure you want to talk bad about Brian?
So you do
Only
have...
when he's not here.
Only when he's not here.
And I believe I've got your name as Chase Beard?
Chase Bearden.
Bearden?
Yep.
Okay.
With the Coalition of Texans with Disabilities.
Okay, if you don't mind, Mr. Bearden, if you could fill out another form before you
Yes.
leave.
I will definitely.
And then I'll get on to Brian when he gets back.
I appreciate that.
Go right ahead.
All right, first of all, thank you. The Coalition of Texans with Disabilities advocacy organization around the state, and one of the areas in this that we really want to make focus is the accessibility portion. I think when the disability community gets spoken about, sometimes the focus is on a very small portion of it, and it's not, focusing on people who are visually impaired or deaf, those are easier to accommodate in the vehicles, and they've done great strides to fixing some of those issues. But finding wheelchair accessible vehicles, it's been an issue over the years, traveling, flying into different destinations for work. I work downtown. I also serve on the Texas Board of Architects and have to go back and forth to that building, trying to catch a cab in time. It's difficult because for the accessible ones, you tend to have to call ahead, find one. You don't know exactly when it's going to show up. Technology is kind of that leveling of the playing field for many in the disability community, especially those who have speech impairments, trying to call in to find that accessible vehicle. Being able to pull up your phone and have access to that and know when the vehicle is going to get there helps you plan out your day, helps you make sure you can get to your meetings on time and not wait. Right now, we do need that focus with the pilot to make sure that this is done in a way that there's transparency. So as these plans come in, I think it would be great to be able to see some of those accessibility plans so that people in the community can say, hey, here's things that may not work, here's things that will work. As we're going through the process, make sure that if something is not working in one of the pilot areas, that it gets addressed quickly so that we can show that this is successful, because we don't want to end up at the end of 2 years and have it where the way it's written in some of the areas, well, we didn't have any vehicles, there was no one in that area that could service them, so we fulfilled our need by marking that off. Also looking at the cost difference. Right now, if I go to book an accessible ride, but then in the past, what used to happen here in Austin, if I went to Lyft, it would pop up and say, call Yellow Cab. That was what popped up on my screen. I couldn't track it. I couldn't use any of the software then. If that's the case, when I would call Yellow Cab, if I was going to do that, and I booked that same trip, I had to pay more. So you're kind of losing the same fairness in financial choosing your ride. Other areas to look at within the rules is making sure that we see that accessibility across the board, and we grow this because it's something that's going to be needed. We're a growing population. We have baby boomers coming on. And then I will end with one last part. In the rules, it talks about four-door vehicles being what can be used. Recently, a young man that just bought a new van so that he could drive. He's in a chair, has a wheelchair-accessible van, wanted to be able to drive people around. So he got on with Lyft and Ride Austin. He was driving people around successfully, making money, which is a great thing because the unemployment rate in the disability community is extremely high. But after HB 100 passed, it said four-door vehicle in there, and a majority of the accessible vans are not four doors, they're three doors. So that is something in there that might need to be adjusted. That's a simple accommodation. He shouldn't have lost a stream of income because of the amount of doors on a brand new vehicle that are installed. So I would ask that y'all look at that and see if that's even just a basic accommodation that could be allowed. We make accommodations under the ADA all the time, and I think that would be one of those, especially in employment, to help increase possibilities for work. Other than that, I want to thank TDLR for all the work they did on that. And if you found that form,
Well, I was about to tell you, Mr. Bearden, I would encourage you to go ahead and give Brian a hard time, but
I will.
I did find the form, so it was hidden underneath.
We know where the
form.
incompetence was.
Perfect.
We know where the incompetence was. And on behalf of the commission, I apologize.
Rick and I will hold him down if you want to take a swing.
Hey.
Mr. Bearden, can I say something real
Yes.
quick? First of all, thank you. I don't know what I don't know, which is a lot, and your paradigm is important for this because I think sometimes it gets lost in the shuffle. So that it is imperative, and I say that word with utmost emphasis, that your position and paradigm is established in this whole conversation because that is important. As a vendor, possible vendor opportunities, which is informative for us, but as a user, an end user, and it isn't, in my opinion, fair that a ride would cost more because you might need it. And so as a commissioner, I am asking you to stay on us on this because this is going to be a living, breathing document, I have a feeling. And the evolution of it is going to be imperative because we're not going to know what you know. So I applaud you for coming and talking to us directly about this. And again, you have my full attention on this, and I will make sure. And if you see of anything that we may be aware of as far as the disability area, please feel free to contact us or anybody directly because that's an area, again, in the mix of things, that small percentage does count, and it counts significantly, and it's important that are on that end. So thank you.
Appreciate it.
Any other questions for Mr. Bearden?
Mr. Beard, what is your experience now? I mean, are these avenues opening up for people with disabilities, or are you locked out right now?
There's a few, and it depends. I fly in different parts of the country, and some places there's a few options. It's very difficult. In Texas, for me, a lot of times I will actually drive all the way across Texas, so I know I'm guaranteed some kind of ride when I get there. Makes it kind of difficult with work. But in certain, like in Austin right now, Uber did come back. Last weekend, I had a board member, our president, come in. He has a speech impairment. He uses a power wheelchair. I was able to book his rides, even though I wasn't at the event, which made it extremely easy for me instead of having to call once the event ended at 10 o'clock at night and him wait 2 hours to see if a ride was coming. Because that's the thing, you don't know if a ride's coming all the time.
What service did you use to book his ride, if you don't mind?
I used Uber. They have one of their accessible vehicles back in town. They had started a pilot before they left. So I was able to use that one. It was the easiest. under, like, if you go to Z Trips right now and you hit the accessible button, you actually have to then call in, because they can't book the accessible ride on there. And I think that's important with all of them, is that if you're going to book an accessible ride, it still needs to be tracked, and you still, even if it's a third party, you need to be able to see where that vehicle's at. Because it's the same security features, too, that everyone talked about as a benefit during the legislative session. You know, a parent booking a ride for a child in a chair should be able to see where that kid's going, or any family member. So I think if we're going to use third parties, you need to make sure that you get all the same features in doing that, and that we're able to track it. And at the same time, if you can't, within the reporting, it has in there how many times someone activates the phone and tries to book an accessible ride, and there's no one to pick them up, so they decline it. Well, I can tell you, if you do that to me more than once or twice, or you put on there, call Yellow Cab, I'm never going to turn the app back on.
Sure.
So that kind of report later on is not going to show accurately how many times I tried, because if I show up to this building and there's stairs every time, I'm not going to use it.
I want to echo Commissioner Figueroa. Thank you so much for coming and giving us your perspective. That's what we're here for. We're here to service the everyday Texan, and that's what you represent here today. You are the only everyday Texan that has come up and given us your perspective. And so thank you, and stay honest. Your perspective is known to us, and we will incorporate it into what we do from here on out, but that doesn't mean we don't want to see you again.
Appreciate it.
Thank you.
Mr. Beard, I'm sure that if you had a chance to read the rules, there is a pilot program that's supposed to be set up, and the time frame, it's very difficult to follow. I put it mildly. But there is a pilot program that's supposed to be implemented by TNCs, and we hope through that we can figure out some things. I wish that it was not as stretched out as it is, but it is. And of course, it's kind of following what the statute says. So,
Well, and also one thing in there, it says one of their 4 biggest markets. I would strongly suggest not just going for the bare minimum, because this is a pilot. As the legislature moved through this, it's when it ends, I can tell you, the flexibility TNCs are getting in this right now is to give them a chance to figure out the best way. And we were all for that. Our organization wants to use technology and innovation to improve the system across the board. But if the end goal is just to get extra time not to comply down the road, then there are plenty of other organizations that are ready to fight constantly to make sure that they get that right for access, because it's taken a long time. ADA was passed a long time ago, and for me, it happened in seconds. I broke my neck. Everyone gets touched by it eventually. You may not need it right now, but I can tell you over the long haul, we all somehow have a family member that deals with it. So integrating it at the beginning as these companies are growing is much easier than waiting until they're larger, and then they're going to be told by the state, here's the requirements you're going to meet. I'd much rather work and build the flexibility right now with everyone.
Mr. Beard, you know there's an advisory committee on this, right? No good deed goes unpunished,
That's right.
sir.
I've served on plenty, so I'm more than happy to.
We would love to get your input, and if not you, part of your organization, and from different perspectives, whether it's visually impaired, hearing impaired, which the gentleman brought up earlier, people who want to pay cash. There's a lot of different paradigms we need to take into account. So I'd love for you to submit your name to our organization or someone of your representatives.
And we got plenty of money to spend on those rides, so.
appreciate it.
We're more than
Thank you,
happy.
sir.
Thank you so much.
That's the end of our comments. I'm now going to have Charles Johnson come up, who has been spearheading the rules and working with the various entities on this. So Charles will kind of give us a little perspective of how the rules came about and kind of what the function is based on statute, how the rules were applied. So, Charles,
Thank you,
go
Mr.
ahead.
Chairman. For the record, it's Charles Johnson, Assistant General Counsel. Given the time crunch, I'm going to be as flexible as the meeting has been and deviate from what I intended to do, which was walk you through the rules. I think that you've reviewed our written summaries and your material, and you've heard the issues that have been raised by the airports, essentially, as well as Chase. The comments, to be understood in context, I think it's important for you to understand the approach we took to these rules. After the stakeholder meetings, we met with the airports individually, I'm sorry, as a group, and we walked out of that meeting with the understanding that they wanted to be able to play in their arena with minimal interference. And so we took that as a approach to these rules. We met with the TNCs. They wanted fairness in the fee-setting approach. We took that as a guideline. We met with the disability groups, and in a word, they wanted access. And so we took that as the principle to try to balance these three groups. The unspoken stakeholder were the consumers. And so we took that into consideration in the balancing of the positions. And so you heard discussion about fees. The context for the fee discussion, I think it's important that we lay that out. The statute allows the airports to set reasonable fees. Reasonable fees we took to mean not unbridled discretion, but a standard. In the questioning to the airports, we asked them, by what standard would you use to determine fees? The response was fair market value. The answer, the question we asked them was, by what standard would you set fair market value? To this day, there's been no response. What we get are the FAA guidelines, the federal statutes, which we have gone through. And you see in your material, the recommendations that we're making to these rules address fair market value. Now, we started from the concept of pre-House Bill 100, when the airports were free to set rates based upon their interpretation of fair market value. And that's why you see in 9510, A1, the reference to the rates that were in effect on May 29, 2017, because those are the rates they set without governmental intervention. Those were their interpretation of fair market rates. And so the starting point was, if those rates were fair and based upon federal regulations, guidelines then, they're fair now. Understanding that over time, economic conditions change, and therefore we built into the analysis an escalator. The revised escalator you have in your material allows each airport to select specific escalators tied to their geographic area. We didn't attempt to select the escalator for them, but to allow them that discretion to search the universe, find the escalators that fit their geographic area, and escalate rates which are already fair and reasonable. That was the first thing that we did. The second thing we did was to recognize that not every airport would want to take that approach. And in doing that, we put in place the ability for them to, they want to call it cost of service regulation. But we recognize the market always considers cost. Nobody puts a rate in effect that loses money, that's less than cost. So the second option allows them to identify their cost, to recover a return on that cost as a market would insist be done. They may take issue with some of the mechanisms in that cost factor, and I think we can talk about that. But to say that that second option is a cost of service, Dallas-Fort Worth, their presentation, they talked about cost recovery. San Antonio, he mentioned cost recovery. Now, the important piece to remember about the cost recovery mechanism, no matter what it is that the airport regulations, you heard discussions about aeronautical and non-aeronautical cost. The aeronautical costs are regulated by the FAA. We've set those aside. The non-aeronautical cost is what we're talking about. And we're not talking about all non-aeronautical costs. We're talking about a slither of those costs. Just those costs for the TNCs. The hotels, taxi cabs, the bus services, the limousine services, we're not talking about those. Their objection is not to us, but to the statute. Because the statute, when it was implemented, changed the landscape. Before House Bill 100, all these services were unregulated. So their argument is not with the rule, it's with the statute. Because the statute now has taken what would have been an unregulated enterprise, TNCs, and now regulate them. These airports are operating and exercising a function of the state. You could not, in your own right, or any other state agency in its own right, could not unbridledly set a fee. There would be a standard and a mechanism for arriving at that fee. All the rules do is put in place 4 options. Adopt the fees that were already in compliance with FAA regulations, perform a study to identify the costs that are being incurred on behalf of the TNCs, just that slither, or adopt a fee that was in place by another airport of comparable size before House Bill 100, the passage of that bill, which would also be in compliance with FAA regulations. And the 4th option is by mutual agreement. And we all understand that a fair market value price is a price that a willing buyer and a willing seller agrees to, makes the market. So that 4th option is clearly on its face fair market value. We took that into account for 2 reasons. Well, for one reason in particular. You've heard discussion about challenges to the statute, challenges to the rule. Well, the statute talks about reasonable value, reasonable fees. The FAA guidelines talk about fair market value. Those 2 may not necessarily be the same. And so the rule is an attempt to line those up, to say that a reasonable fee under the statute is fair market value. That's all the rule does. It does not impact their other non-aeronautical fees that charge, does not impact the regulated fees that are charged to the airlines. That's a misdirection. We're talking about a slither of their services. So that's the response to the argument, and I think we summarize it in the material that you have in front of you. That's the approach that we took at presenting to you options. Because the FAA also says that there is not a single methodology for determining fair market value. So in recognition of that, we presented a rule with an option. Each of those options is a pathway and an approach to fair market value. And so another piece of that rule is that they talk about and say what the rule does. If you read that rule carefully, what it says is that nothing in these rules shall be construed to require or compel. But it does say the parties can agree. And then we set out guidelines for those agreements. Because we understood that by giving broad guidelines inside that airport, they could play. The market would work. It would work in this sense, is that they say each airport is different. We agree. Nothing in these rules prevent an airline from negotiating a rate with a TNC, which says we recognize that taxi cabs take up space. Some airports want staging areas. Some airports don't want staging areas. So some TNCs could negotiate to say, I want a staging area, and I'm willing to pay you more for that. That's the market, mutual agreement. Some airports could, some TNCs could say, I don't need space in your airport. I want a lower rate. Negotiate. So we have put in place a set of rules to allow the market to work based upon the particulars of the airport and the needs of the TNCs. Tracking, software tracking. You heard discussion about ghosting, the ability for drivers to leave cell phones outside the airport grounds, the tracking. In your material, there's a discussion that talks about the ability, and these issues are real. The issues, they've been addressed in California and elsewhere. The ability of a TNC to change the logarithms in their network to defeat tracking mechanisms, okay? And so we realizing all these issues that they're dealing with, what is the most direct way to address the concerns of the airports? The statute prohibits the compelling of data. Well, the best data to determine revenue is the same data the TNC is using. And so the rule is set up to allow an airport, because the statute also says that an airport has the right to set rules and regulations. Some of these comments and things they're asking us to do are within the power of the airports to set up. They have the power to impose regulations. And so nothing in our rules prohibit an airport from in its rules to agree to negotiate agreements to do any of this stuff. But the statute prohibits the compulsion of data sharing. And so if the best data is the data the TNC is using, we agree with the City of Houston. Audits. Audit the data the TNC is using. That is consistent with the statute because the TNC is not, the airports don't see that data. The auditor, and that's what the purpose of the independent auditor, who shares nothing except verification of the data and the cost. I'm sorry, the revenue that that TNCs have paid to the airports based upon that traffic flow. And so we went to the source of the data to skip over these issues that the airports acknowledge are issues. With respect to the pilot disability issues, and because we committed to the disability community, that we would recommend to you a set of rules that provided them with meaningful access. And as you see, the statute as it's set up sets up a pilot project. And so we can only work within the confines of that pilot project. One of the comments that Chase made was about the workability of the apps. We put in place in this rule a requirement that, let me take a step back. The statute provides for 2 reports. One report is a compliance report that comes to the commission. The second report goes to the legislature at the end of the pilot project, which will be 2 years and which will expire after the end of the next session. And so what we have done in the reporting process is one of the sections of the statute, I think it's subsection A, I think of 113, requires that the compliance report to the commission, that in that report, the TNC demonstrate that their pilot project provides access to the community. And so with that guideline of access, we wrote a set of rules to require the TNCs to track meaningful data to show that they have in fact sat down with these alternative providers, set in place mechanisms to track their vehicles, their response times. Because as Chase said, it makes no sense for a TNC to say, I'm complying with my pilot project because I refer to a third party, but I can't track the data. I mean, that circumvents I think the letter and the spirit of the statute. And so that pilot project is put in place to do just that. I know there are other issues that are addressed, but I want to address the big issues because those are the issues that the airports are complaining about. Now, with respect to the language of trips to and from the airport, we recognize that there was an oversight in the combining those two provisions. And so your revised rule inserts the ability of an airport to track traffic to and from the airport, because that's how they are able to charge for trips that originate off airport and that terminate on the airport. If you give me 1 second, make sure I didn't miss anything. Oh, at the public hearing, that hearing started out with a global statement that this rulemaking was not an attempt to relitigate the legislative session. And so through these comments, we were able to identify those issues that were discussed and rejected by the legislature. And so I think there's 14 issues in your material that we've identified, specifically fares, the display of insignia, and I'm going to speak to the insignia, because there are 2 sections in the statute that talks about the vehicle. We're following the concept that when a statute sets out a list of requirements, we can't add to that list. And the legislature addressed what goes onto that vehicle in the statute. The legislature also gives the airports the authority to set and to put in place driver identification. The statute goes so far as to say that they can request a driver to bring out their phone, show them they're on the network, but they can't take the phone. I mean, that's how detailed the legislature went into this issue about driver identification. And so I think we would be overstepping, and I think you'd hear comments to that effect if we were to recommend to you a rule that went beyond what the statute says.
Charles, can I ask you a quick question?
Yes, ma'am.
Chase, or Mr. Beard mentioned that there was an issue about the doors, and I'm going through the statute looking, or the rules, and I'm having trouble finding where that might be.
I don't know the section, but he is correct. There is a section which talks about the vehicle, and it refers to a vehicle with 4 doors.
Would it be a problem to insert or add, because I don't want to change the 4-door aspect, because I think there's some valid reasons why it needs to stay at 4 doors to make sure they're all functioning. But is there a way to add in it in the case of an ADA compliance vehicle, 3 doors would be acceptable? Is that something we could do today?
Actually, I think it is because I was also talking with Michael, a.k.a. Ford. I think that it depends upon the van, because I think every van has at least 2 doors, and if it's
Well, I was looking at it
been,
online.
if it's been modified so that the back doors, which would normally be open and closed 2-way.
No, I think it's, see, he is right, because one of our dear friends has a ADA compliance van.
Your notice thing popped up.
And you can see,
If I may approach.
one side, they've joined the 2 doors into one large door. So that was why
That's
it's,
the easy fix.
yeah.
I think the easy fix is to interpret the original vehicle having 4 doors, the modifications don't count. And it appears that that vehicle was modified in order to make it accessible.
Well, I don't know if they make them from the factory, so I don't know if it'd be considered a
But
modification or not.
I think that we can craft language to include those vehicles in the pilot project.
I would just like to, can we do that, when we vote on this, can we do that today, or do we have to?
If you will include that in your motion and authorize staff to craft the language, we can do that.
Okay. And I assume that would probably address Mr. Bearden's issues that we had.
I would assume so, but I won't speak for it.
Well, because it says confirm that the vehicle has 4 doors. Would the hatch be considered a door?
I would consider it a
Yeah,
door.
you have to look at it and
So
understand.
that may address the issue that he was talking about with the 3 doors, that now has a 4-door requirement. I guess we can include
But
that as being in the back.
if you would include that in the motion, if you would include in your motion, authorize
Just to
staff
authorize
to talk to Mr. Barrett, we will work that out. But I think there's an interpretation that we can craft that's consistent with the statute and meet the needs.
Well, at least have one industry walk away from here happy. Yeah, any other, Charles, is there anything else? I mean, we need to move along because we're about to lose quorum.
No, sir, I think that covers the larger issues. The other changes to the statute are in your material, and we'll, if you, will- unless you have a different opinion, we would incorporate any motions to include those edits, and we will incorporate them into the final version of the rule.
You know, and I think that one of the things that we have to understand is like any other program that we have, these rules are fluid, and we have the ability to come back and modify and change the rules. Again, understand that we don't go outside the scope of the statute, which is something that we don't want to do. And I hope that the TNCs and the airports, in this particular case, because those are the ones present, understand that I think it's incumbent upon us to review these rules on a very timely basis to ensure that we're meeting, first of all, the requirements of the statute, but second of all, addressing the concerns that may arise from the implementation of these rules. And then also the ability for us to evaluate comments made by all industries to see if the comments that they made are actually coming to fruition.
Yes, sir.
And then for maybe each industry to understand, or maybe each industry to be able to state, okay, well, we thought this was going to be an issue, it has not turned out to be an issue. So I think it alleviates some of those things coming along. So I hope that all the industries understand that we have the ability to come back and address these rules at any point in time. We're not prohibited to simply adopting the rules now and not picking them up again until the statute change. We can look at these rules at any point in time.
Yes, sir. And given that this industry does not have an advisory board, I think that's consistent with the agency's overall approach to all industries, is that when if you adopt these rules today, we're willing to talk tomorrow about what's going on. And so that discussion is an ongoing, I think, obligation on our part to keep the communications open and to address issues as they arise within the industry and recommend to you accordingly.
We don't have an advisory board yet established for this, is what you're saying?
No, there's not
will
one to be
not.
established. This is a department-driven process.
And that's where it starts getting into the weird kind of quicksand of setting a framework for fees outside of the marketplace, you know? I mean, that's just not something that we do.
Well, see,
We license an electrician goes out there based upon the competition and what services he has to provide. And he says, I can do it for this, and then the customer can go shop. But you have one airport that you fly out of, you know, that's, it's not easy.
Is there something that you were given that you need to address us with?
Yeah, if I may make one additional comment. I was just, apparently a discussion took place, and we don't have any objections to in the 9510, the references to the surplus revenue. We don't have any objections to striking that language. That was inserted because there was, we understood to be a requirement by the FAA that airports don't impose fees that will generate excessive surplus revenue. I've had a discussion with, I think, Dallas-Fort Worth, and their concern was they thought that applied to the aeronautical services and assets, and not to the non-aeronautical pieces. And so I don't think it does any harm to the rules to strike that language
And
from
tell us
the non-aeronautical.
specifically which language we're talking about.
It's the language
It's in
in,
9510B.
B, it says B now.
yeah, actually, it changed when we reformatted the rule.
It's on the
Let's
next
see.
page.
It's 9510B 1B. It's on page 2.
Where it states calculated,
Yes.
started with calculated.
You want to strike that?
So we would strike all of B?
No,
or
no, no,
Just
sir.
the ending of it where it says
Just-
create revenue or
ju-
surpluses?
Yes, sir.
So we would basically put a period after discriminatory and strike the comma, or create revenue surplus.
Revenue surpluses, yes, sir.
And Charles, I want to put a finer point on something that I may have misheard. Did you address the tracking?
Yes, sir.
A minute ago, and you said you're comfortable with.
We were of the opinion that the audit issues address the tracking, because the audit issues are superior to the tracking, because tracking is defeated through the ghost phone and all that other stuff that you kind of heard about, how the drivers kind of circumvent the airports.
And so, do we need a separate rule for the auditing?
No, sir, it's already in here. It's in, give me a second.
Oh, I got it. It's right, A1, right at the beginning of 9510. Third-party audible
Yes, sir.
resource.
Yes, sir. And again, in closing, unless there are other questions, we have attempted to be responsive as possible within the confines of the statute to address the issues raised by all the stakeholders, and we recommend that you adopt the rule as discussed and modified through these discussions with an effective date of December 1st of 2017.
Without actually trying to draw up my, or bring up my batting lineup back up again, I think that striking of the rules, we hope, would be able to help when we talk about creating revenue surpluses. I hope that that would be able to I was going to say appease, but I would say probably lessen maybe the impact of what these rules are. Again, I go back to stating the same thing. This is a very fluid conversation. We hope that you continue to talk to TDLR staff. We hope that you continue to be able to bring forth your recommendations and comments. This is not the end of this conversation, is what I'm asking. I hope that you continue to stay in contact with not only our general counsel, but our executive director, and us, if you need to be able to communicate what your positions are. Because this is, I can tell you, this is a new program for us. We've seen a lot of new things happen. In the last session, we got a lot of the new things happen to us, which are the health-related programs. And now we have this new thing of the transportation network companies. But I would probably probably tell you that based on the fact that you have had to deal with TDLR, I would hope that you would say that we are responsive, that we do listen to what you're saying, and that we would be able to at least keep that line of communication open with you at all times.
And Mr. Chairman, if I may add one more thing to the record that I neglected to say.
I was supposed to finish off like that.
Charles has to have the last word.
I know. Go ahead.
Is that we were also mindful, and I want to put this on the record, so because I understand what you just said, but we crafted these rules when out of the courthouse, and so for the record, the FAA guidelines specifically say that fair market value is to be used to the extent practical under the circumstances. And under these circumstances, we believe that these rules are carried forth the intent, and so we again believe they're consistent with the FAA regulations.
Thank you.
Chairman Butler. It's just a small, quick thing. This is the beginning of a conversation, and we want to know the impact that our decisions have in the real world. We're not tied to a methodology or a philosophy. We want to do what works for everybody. So if something's not working for you, let us know. The obligation is on you to make us aware of it, and then we can come back and fix it. We don't want to hurt anybody. We're trying to do the best for all parties here. So please let us know how it impacts you going forward. Okay?
There's a recommendation by General Counsel to adopt the rules with the modification or the amendment of striking or create revenue surpluses from the current rules that are before the Commission at this point in time, with an effective date of December 1 of 2017. Is that correct?
As well as to authorize staff to insert an interpretation that allows for these vans to be used as
Three-wheel,
for accessibility.
A
Yes,
flexibility
the
to
accessibility.
accommodate.
Yes, 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 ma'am. Yes, sir.
Accessibility. So, which I believe will help you guys out. Is there any other questions or comments? A motion would be in order?
So moved.
We have a motion,
Second.
a second. All in favor signify by saying aye.
Aye.
Aye. Those opposed?
Nay.
The motion carries 3-1. So, you guys now have some rules in place.
Thank you, Commissioner.
Again, continue to communicate with us. Last item I would talk about is our next meeting date. We currently have the meeting date scheduled for December the 8th, is that correct? And we've now had to change that. And do we have a date?
Mr. Chairman,
Yeah.
this
We're
is the...
proposing December the 15th.
Mr. Chairman, I'm sorry to interrupt. Is there a possibility of taking up one last motion for a hearing on a very, if we talk very fast? There was one motion for a hearing we're going to ask the commission to take some action on. If not, we can find another way to address that going forward.
Let's find another way to address it.
Okay, thank you.
All right. We have the next date has been now proposed for December the 15th.
I'm good
If
with that.
You're good?
I'm good.
So why don't we set it for December the 15th? And then we know we got at least 4 that can make it, so. And Kay will send out an email to everybody about the other future dates and take a look at your calendar. I would ask that you respond to her rather rapidly so that our December 8th meeting, we can set forth meetings going into, all the way into mid-2018.
Yeah.
So,
Move to adjourn.
there's not even a motion. We're now adjourned.
Okay, I'm out of here.